No objection.
Why not he is requested, sir?
Okay. So then, item 3.
Yes.
Okay, Mr. Enrata. Land Council appearing on behalf of the respondent.
No. On the appeal is by the state.
Sorry.
Okay.
Land Council. Sorry, Land Additional Advocate General appearing on behalf of the appellant. Submits that he has yet to receive the proper instruction in the matter. Therefore, pray for adjournment of the matter for 3 weeks, to which Mr. Arsai Galan, Senior Counsel, appearing on behalf of the respondent, has no objection. Accordingly, the prayer is allowed. Please the matter after 3 weeks. Okay.
Your Lordship, I beg to mention item number 17. Lordship, this matter was endorsed to late Jeet Ado, Your
Okay,
Lordship. So it has been re-endorsed to me yesterday. I need to look into the file, Your Lordship. Your Lordship may grant some time.
My lord, matter will be fixed after 4 weeks, my lord.
After 4 weeks.
Yes.
Okay. Mr. N. Rama, Lana Counsel for Appellant, is present. Stop. Mr. Jine, Lana Additional PP submits that earlier this matter was endorsed to Mr. Tado, who is since deceased. Now the matter has been re-endorsed to her. Therefore, she prays for some time to go through the matter. Is voted by both the Lana Council for the parties. List the matter after 4 weeks.
Deep.
Item number 1.
खत्म कर देंगे. Step selection function. Already कोई देख कर लो तो ले. Step selection function. हम ये सब देखें. बस by block देख बैठ. Sorry, huh? Yes,
My lord, in this case, staff petition also filed an affidavit, and I got it yesterday.
It was by long days back, my lord.
But I got it only yesterday, my lord.
18 February 2020. It was filed.
Yeah. Mr. Chandra, the only issue here we find is that the Central Administrative Tribunal has drawn some conclusions in its order, more particularly in paragraph
6, man. 6 and 9, my lord.
9. Where is this material to draw this conclusion? Para 9.
Para 9, my lord, in their, they have enclosed, in their writ petition, they have enclosed some materials. And I have now collected.
No, from where did the cat get this?
From their submission and from their
The issue was that there was an advertisement.
advertisement.
In the advertisement, you had to have Hindi, English in the degree courses also. That was the.
That was there, my lord. I am having it. But 3 years Hindi.
Just
3 years Hindi. Their objection is that I don't have 3 years Hindi in BA course. 3 years Hindi. In the recruitment rule, it is not there.
No, but in the advertisement.
Advertisement cannot, my lord, I have brought the judgment. It cannot be during the recruitment rule. And that is my.
So that the recruitment rule for this post.
Yes, my lord.
What is that recruitment rule? This was not the issue.
My lord, this was not simple. A simple notice was issued.
No.
Simple notice was issued that under 501, simple notice was issued to terminate.
Fine.
Without disclosing
Fine.
anything.
Fine.
Without disclosing anything, my lord.
Fine.
That after 1.5 years of mine.
We get you. But the pleadings that have been brought on record demonstrated that you did not have this qualification.
No, that,
So So the issue was whether you had that qualification or not.
As per the recruitment rule, I have got the qualification.
So that was not even considered by the
But-
learned tribunal.
As per recruitment rule, this is the
No, no,
recruitment
the
rule.
learned tribunal did not consider that issue.
May I bring it, my lord, through affidavit? There is no note, my lord. Note is given, it is your the rule. Hey,
But you have never taken up that plea anyway.
it is not disclosed, my lord. In the show cause notice, it is not disclosed at all.
No, even in your pleadings in the
No, it
tribunal,
is
it's
not
there.
disclosed, it is. Now we have got the recruitment rule. So that note is not there. This is the CIG 2017 recruitment rule. Lordship may come to page 5. I have given the numbering, page 5 and 6, 2017 recruitment rule.
Advertisement was on?
Advertisement of 2017.
What is the date of the advertisement?
2017, my lord.
3/3/2017. When were
Yes.
these rules notified?
This rule is
16/6/2017. So it's after
no,
the.
earlier recruitment also this note is not there. But may look into the earlier recruitment. This note is not there. In earlier note also, this recruitment rule is not there, my lord.
You are a master degree in?
My master degree
Master degree in which subject?
in English.
English. And do you have Hindi?
Hindi also.
Where? In the degree?
In BA course. BA course. I fulfill otherwise. 3 years Hindi is not there, admittedly. 3 years Hindi, it is not there in the recruitment rule. It is not there in the recruitment rule. I have got the recruitment rule. Even 2000 recruitment was the
But
first
it says master degree of a recognized university in English
English.
with Hindi as a compulsory or elective subject or as a medium of examination at the
Yeah.
degree level.
No, their objection is 3 years Hindi. Their objection is only 3 years Hindi is not there. Note.
But
my
these
lord.
are not the issues which
Yes.
were urged by the tribunal.
No, now they was not disclosed even.
No, the tribunal went on a different footing altogether.
My lord, these things were not disclosed, my lord.
Then
That point of time.
why did it draw this conclusion at para 9?
No, on their submission they have drawn. May I bring this, my lord, throw an affidavit? Bring this on record.
She is not working now.
She is working.
She is working.
She is working. And my lord, interestingly,
my lord.
another judgment was passed
No.
on the same analogy. I have given in my affidavit in opposition, one of the affidavit in opposition.
My lord, she is not
That
working,
was
my lord.
that was not challenged. That was not challenged. That is also Sujit Kumar.
Mr. Soikia,
My lord,
in the advertisement, if you come to page 44,
my lord.
where there is no model RR,
My lord.
then these conditions would come into being. But he says they have a model RR. If there is a model RR and this 3-year prescription is not there, how can you read it into that?
My lord, we have never came across this, my lord. My lord. My lord, let them.
Find it.
Yes, my lord.
Mr. Chondo, it's very hard customer.
My lord.
No. And the other case, my lord, they have not prepared any appeal. And he is working, my lord. That is
Mr.
Sujit Kumar.
Saikya?
3 candidates were declared disqualified. And that too behind the back of the petitioner.
Counsel for the appellant staff. Also had Mr.
M.
M. Chandra, counsel for the respondent staff. Mr. Chandra, counsel for the respondent Sami Stat. Praise for allowing him to bring on record the recruitment rule to the post of junior translated in India did an account department. No. This is,
That is the book. You get it.
and
This is the latest. This is not.
what is this one?
Page 5.
Okay. Hindi.
What is the name of these rules? The old rules?
Old rule is, my lord.
Audit.
These rules may be called the Indian Audit and Accounts Department Junior Translator Recruitment Rules.
Where do we find that?
Page 4.
Okay.
Page
Hang
4
on.
in the top.
The recruitment rule. Indian Audit and Account Department Junior Translator Recruitment Rule 2000 on record by filing additional by way of filing additional affidavit. This also?
No,
Okay. The prayer is allowed. Such affidavit shall be filed within
Let it be on a fixed date, first
Okay,
week of September, my lord. 3rd September.
okay, within 2 weeks from today. Okay, first week of September, okay, on the request of board. Mr. Rintu Saikia, and Senate Council, assisted by Mr. Is present on for the appellant, Mr. P. Kato, Lani DSC for the respondent number.
2 only.
4 is also present. Stop as requested. Let the matter be listed again on
On 3rd, my lord.
3rd September.
DPO. list.
Item number 2.
May assignment.
Yes,
The pleading mallet is over in this case, mallet.
yes, yes. Okay, you have received the copy
Yes, Lord.
file, okay.
Mallet, my only issue, mallet, here is mallet. There is law is in place, mallet. There is a law in place, mallet, prohibiting mallet lottery by individual mallet, person mallet. My understanding of this law, mallet, is the lottery mallet can only be conducted by the state mallet. That is the now they have filed earlier mallet. Now they have filed affidavit mallet saying no, this lottery, the Lottery Regulation Act 1980 does not applicable to the lottery conducted by the private mallet.
Yeah.
Now that mallet, my humble understanding, mallet, that is a misreading of the law, mallet. I believe, my lord, this law itself is clear, my lord. Law I have enacted page 34, my lord. Now I believe, my lord, they have read section 3 and 4, my lord. On the basis of that, they are saying making this submission, my lord. Now, if I may allow, my lord, I read 2, 3 part, my lord. This act say, my lord. Objective, my lord. I will start from objective. Page 34, my lord.
34. Yes,
This act to regulate the lottery, my lord, and to provide a matter connected there with an incidental there to, my lord. Now, this is important. This particular act was enacted to regulate the lottery, my lord. It doesn't say by the state or private, my lord. Now, important, my lord, they may be relying this section 3, my lord, provision of lottery, my lord. It's a safe and otherwise provide in section 4. No state shall organize, conduct, or promote any lottery, my lord. Maybe they are saying, yes, there is no state, my lord. It's a no state shall may bear this is not applicable private, my lord. Now, my lord, 4, my lord, conditions subject to which lottery may be organized. A state governments may organize, conduct, promote lottery subject to following condition, namely, my lord. Now, by reading this, they are saying, my lord, maybe they are saying state this act is applicable only to this, my lord. Now, my humble understanding, this act, my lord, this cannot be read in isolation, my lord. This to be read as a whole, my lord. Now, if we turn to personal, directly in kind of my lord, penalty, my lord, prescribed, my lord. This is section 7, my lord. Page number 35, my lord. This is a penalty part of this section 7.
Mhm.
1, my lord, where a lottery is organized, conduct or promote after the date on which this act received a sign of precedent in contravention of the provision of this act by any department of the state, my lord. My lord, you know, this is by if this applicable to any department, my lord. Suppose state. I'm skipping other part 2, my lord, not withstanding anything contained in subsection 1, where a contravention under this act has been organized by department of government. I believe this also applicable to the government, my lord. Now, my lord will kindly that subsection 3, my lord. Subsection 3 say, if any person act as an agent or promote or trade in any lottery, organize, conduct or promote, my lord. Now, my lord will kindly note here, it not say promote or organize, conduct or promote by the state, my lord. It say in contravention to provision of this act or sale, distribute or purchase the ticket of such lottery, he shall be punished is rigorous imprisonment for term which may extend it to 2 years with fine and deport, my lord.
There were some judgments of the Supreme Court. Are you carrying that?
Exactly.
You have
Lordship, one citation I have placed, Lordship.
And the Magyara,
of
This is of 23 laws.
Karnataka.
Karnataka laws.
Oh.
Here law, I have
Just cannot. Oh, it's here. It's.
only come to paragraph 97, Lord. Makes very clear law. This regulation is not applicable for the lotteries are conducted other than the state and.
Benjamin.
You have made
What-
some rules? No.
Mm.
State has made rules.
State has act lawsuit. So far lottery is concerned, that has been excluded also. So far gambling is concerned, lawsuit. In that respect, law is their laws.
But see, there was a Mr. Parme, there was a FIR against you
My lord.
that you also sought permission for conduct and
My-
in fact conducted also, organized also. FIR laws that result was not declared there.
Yes, my lord.
And that before filing, this was before filing or after?
After filing of the PL, my lord.
What?
After
FIR.
FIR is after filing of PL, my lord. But I
But then the conduct, all those
No, my lord.
happened prior to filing of this FIR.
yes, my lord.
Correct lawsuit. And that has been
Yes, it-
suppressed laws.
Why it was not disclosed?
No, my
That has been suppressed laws.
No.
Bona fide is not there.
I will not justify that, my lord. I just try to explain, my lord, up to the my lord. But if in this case, my lord, yes, I try to conduct a lottery with due permission of the DC, my lord. Now I submit application, my lord. Now thereafter I was told, my lord, this is illegal, my lord. According, again, they
No, before organizing or just after publication of all those lottery tickets and after selling of the tickets, you went for permission.
after
Because
I
it was already
print out,
sold.
my lord.
It was already sold.
No, yes, my lord. After no,
Thereafter you
not
went for
already,
permission.
not already sold, my lord. In between, my lord, when I started, my lord,
Or thereafter you went for permission.
permission, my lord. Now I was told, my lord, this is not. I was told, my lord, that this is not permissible, my lord. Thereafter, I was direct to approach the secretary, my lord, and the secretary law, my lord. There I was told, my lord, this is illegal, my lord. Now, accordingly, in terms of that direction, my lord, I through social media also, my lord, try to made a I made a
No, the complaint, the FIR is against you. That although you have sold, date also given but not declared.
no, my lord, that I have explained. That's why, my lord, I already in before filing this, my lord.
And money also not returned.
Return, my lord. No, my lord. Let me, if my lord kindly take up my reply, my lord. I have explained in detail, my lord, in that, my lord. It's not, my lord. That was in a, I filed application, my lord, on my lord, 2024, my lord. So, yes, my lord. I filed application of 4/4/2024, my lord. 4/4/25, my lord. Thereafter, my lord, I even made a press briefing, my lord, declaring this is illegal, so I'm returning, my lord. Accordingly, I return, my lord. And that is also when, after I filed this FIR, my lord, when I filed this PIL, my lord, when the notice was issued, my lord, FIR lost, my lord. And I did explain whole that to the investigation authority also, my lord. But that is not to be published on our report, my lord. The statement I made, my lord, it was in 2024, my lord. Yes, I tried to conduct, my lord. Thereafter only I came to know that it is illegal, my lord. Otherwise, my lord was kindly appraised, my lord. This lottery, my lord, is organized being on daily basis in Arunachal Pradesh, my lord, in the name of a class.
Just, you said that you have lodged FIR before different police station.
My lord.
Is there any instances where you say, because you have seen the affidavit filed by the respondent, all the respondent,
My lord.
is there any FIR you have filed and they have not taken taken any action on that?
No, my lord.
Like-
I say, my lord, my
They
lord
have, all of them have, almost all of them have
my
filed.
lord has seen the I say it is not on the, it is rambling and evasive response, my lord. But today, my lord, I'm not on that, my
No,
lord.
no. So they.
My lord has seen the rambling and
specifically
evasive
they said-
response state, my lord, of the IO also. But my lord, I want to make it clear, my
No,
lord.
still, is there any case
No.
or any FIR lodged by you and which the police station or the police has not taken action on that? Is there any other instance? Because here, in all the cases, wherever FIR was lodged, they have taken steps, registered the case and
No,
investigated into.
my lord, that way, my lord. First of all, my lord, I want to make it clear, my lord.
Mhm.
I made annex this FIR, my lord, not to punish anybody, my lord. I'm not on that, my lord. Today also, my lord, I'm not pressing hold those, my lord. Simply, I want some rule and regulation, my lord, uncontrolled this. I made this only to show the conduct of the respondent, my lord. Now, my thus conduct, my lord, has seen their rambling and evasive response, my lord.
Conduct of the respondent means which one?
All the respondent, state respondent, my lord, and the IO, my lord, game, there is a card, my lord. The name is there, my lord. They are saying they did this punish. I'm not to punish anybody, my lord. Only I pray this honorable from this honorable court, my lord. At least there should be some rule, my lord, and regulation, my lord. Hope, my lord, I'm clear, my lord. I'm not saying, my lord, this FIR should be acted upon. Today, I'm not saying so, my lord. I also only brought this page only to take, let the court take notice of this, that how respondent, my lord.
No, what my lord was asking you, you
Well-
filed this PIL
My lord.
to stop
Yes, my-
illegal property.
Eh,
Then you yourself went and applied for.
No, my lord. That my lord, it can have 24, my lord. I try, my lord. Then I was told this is illegal, my
So
lord. Thereafter,
was this PIL only to get a license there? Pressure tactics.
no, my lord.
This is not the forum for,
Yes, my lord.
your conduct is not
That
aboard. And PIL will be after we examine your conduct.
that
That's what my lord is trying to do.
yes, man. That's why I'm saying that I will fake, my lord, or my lord will balance the my lord. I'm not saying, my lord, this is not that I even suppose this PL it is allowed, my lord. There is no,
Because
Nope.
you are also alleging some community that organizing lottery and not implementing them also. How do we pass any order against them unless you give an opportunity? Why they on what basis they organized, whether they got permission or not, we do not know. How do we pass any order, a blanket order?
That's why, my lord, I submitted, my lord.
Hmm.
I'm today also, I annexed this FIR, my lord, not to punish anybody, my lord, and not against anybody, my lord. I annexed.
No, Lani Council. You file FIR.
My-
You have already filed FIR. On the basis of the FIR, case registered, action taken, already taken, investigation is on. So what more you want?
My lord,
And then you have to now give an instance where you have lodged FIR, but then the police has not taken any steps or not registered or not taken any steps. The police is doing their job. Law, if there is a
Well,
state notification, if this law is not applicable, but the state notification, if it is applicable, based on that, police has registered the case and investigating the case.
my humble understanding, if
Hmm.
we go, if we go by their response, my lord,
Hmm.
I find that is the rambling and very evasive, my lord. If my lord say, my lord, this is the, they are doing.
Which one?
All, my lord, if they are saying, if my lord accept their,
See, Rani Council, Mr. Chairman.
if,
They have clearly mentioned the FIR also, and then a register investigation is on. So clearly they have mentioned, where is the evasive answer?
I will take up every my lord reply, then my lord, but then I'm not saying, my lord, if my lord accept this as my lord, this action in terms of the law, my lord, I have no word to make any submission for my lord. But I only annex to how they are being, my lord, indirectly, my lord, supporting, my lord, sub part of this law, my lord. I only on that basis I have made this FIR annexion, my lord. Now they have filed reply, my lord. How, my lord, they are supporting this law, my lord. If from reply, there's that is clear, my lord. If every reply of the, my lord, if for a moment, if my lord, a reply of my lord, see, suppose this is by responding or tree is not if my lord take up the response of my lord 5, my lord, so 5, my lord. And that my lord, see page number 29, para 3, my lord. I have implemented 5 in this case. I fully acquainted with the conversion with the peg and circumference of 2 other of LS such and such, executive or such and such is organized and committed law at NAMSAI. The said complainant coordinated officer in such NAMSAI for taking the action as part of my lord. In case they have occurred within the region NAMSAI, my lord. In this regard, 0 FI had not been registered at Itanagar fully except for making a CRD on the following ground. Place of occurrence falls under the jurisdiction of NAMSAI police station, my lord. Now, my lord, to my lord, concept of 0 FI itself is that when the cognizable offense, my lord, is brought to the notice of police, my lord, 0 FI need to be registered, my lord. Now, thereafter, they have transferred it, my lord. Thereafter, what happened, it is unknown, my lord. Now, if we take up the reply, my lord, of this is of respondent number. This is by the respondent number 10, my lord. This is start from page number 154, 155, my lord. Para 3, my lord, or 5, they have 1. Well, I'm not, today I'm not insisting this whole FIR should be registered, my lord. I'm not on that also, my lord.
Okay.
I don't want to punish anyone, but before filing this FIR, my lord, I make a public awareness also, my lord, as this is illegal, my lord. I try, my lord, and I approach all the authority also, my lord. So if this is illegal, my lord, this need to be controlled, my lord, regulate, my lord. Now that was not thereafter. Now if my lord take up their reply, my lord, directly or indirectly, they are supporting this, my lord.
Supporting?
Yes, my lord. they directly, undisputedly, my lord, if my lord today appoint commission, my lord. In Arunachal, there is as much as
Just a minute, do we have information regarding the status of the case against the petitioner, Mr. Tapin? Do we have any information regarding the present status of the case registered against the petitioner?
Petitioner, in my affidavit lawsuit.
Mhm.
Apna level. This is affidavit filed by respondent number 11. It page lawsuit 107.
Hmm.
This is the FIR lodged before officer in charge Bapunala Police Station.
Mhm.
It's against the petitioner along with two others.
Hmm.
GD entry is their lawsuit on 10/9/2025 lawsuit. GD number 11.
Yes, yes. So notice was also issued against.
And this is supported by the next lawsuit 108. This is a lottery, a free New Year gift upon 2024. Here the petitioner is the organizing government on the right hand side also.
So that is there, but then
What happened?
whether the case was registered and what is the status if
Date
registered?
lawsuit, we need to take, if that's required, then we need to take
The
it.
credential of the petitioner is required. So,
Lawsuit, may I just from my side lawsuit.
Hmm.
So institute a lawsuit, PI lawsuit, there must be a bona fide on the part of the petitioner lawsuit.
yes,
It's
that's-
supposed to be brought before the court in the interest of the public lawsuit. If lawsuit see the pleadings made in the PI listed lawsuit, now by conducting this lottery by the community on their festival and all lawsuit, how it's affecting the socio-economic life of the people of the Arunachal Pradesh. That part, some study has to be there lawsuit. How it's being lawsuit, their life is being affected lawsuit. Their social life, their economic life, how they are being affected. That part has to be placed before this one of court lawsuit. That is missing here in this particular. And secondly, lawsuit, the bona fide lawsuit. Because lawsuit, the background on which lawsuit this PL has been instituted lawsuit. As now it has been brought when we lawsuit file affidavit lawsuit. Otherwise, lawsuit, it was suppressed lawsuit. That should have been lawsuit. If there was a bona fide on the part of the decisional lawsuit, there should have been lawsuit stated in the PL itself lawsuit. Therefore, on these two count lawsuit, this PL is liable to be lawsuit dismissed lawsuit. That's the one part lawsuit. If lawsuit is the prayer made in the lawsuit PL itself lawsuit, that is the implementations of the Lottery Regulations Act 1998 lawsuit. Lawsuit, as I place one judgment, if there's any confusion whether this regulation is applicable for the private lotteries or not lawsuit. If lawsuit is anti-40 of the union list lawsuit, it makes it very clear lawsuit. Central government can make law only lotteries organized by the government of India or the state of state government only lawsuit. It's very clear lawsuit. Other than this lawsuit, the central government cannot legislate lawsuit. So therefore, on this background only lawsuit, so far regulations 1998 is concerned. That is to regulate the lotteries to be organized by the state government and the central government. It's very clear lawsuit. And therefore, the past prior lawsuit to implement this particular lawsuit regulation is already implemented lawsuit. But that cannot be invoked so far the present case is concerned. That's the thing. Otherwise, we are implementing that lawsuit. There's no doubt on that lawsuit. We have made our own rules also lawsuit to regulate the state organized lotteries lawsuit.
Okay.
And thirdly, lawsuit, the registrations to FIR lawsuit. Lawsuit, there are so many judgments of Honorable Supreme Court also. Lawsuit, Article 226 cannot be invoked, especially PI lawsuit. For registrations of the lawsuit FIRs without exhausting the other remedies available in the procedure law lawsuit. There is no lawsuit that cannot be maintained lawsuit. That's the one thing, Lordship. Therefore, Lordship, on this count, Lordship, this PL is liable to be dismissed. That's what I
Okay,
feel, Lordship.
yes. Mhm. Okay, anything else?
No, my lord. Assuming, my lord, this egg not able, my lord, kindly turn to page 27, my lord. This is my prayer, my lord. No.
Yes.
Page 27, my lord. B, my lord. By this PL, my lord, I'm only not only saying, my lord, this egg need to be implemented. Suppose senior government council submission is accepted that this egg is not applicable, my lord. Then also I am praying, my lord, this is the
Government order.
my lord, need to be implemented, my lord. Because, my lord,
Yes, yes.
my lord, undisputed, my lord, the other side of exam, my lord, we have as much as 100, more than 100 subprime, my lord. Now, every lottery, my lord, is the lottery in the name of festival, in the name of client, my lord, even in the name of colony proceeding, my lord. This is organized on Arunachal Pradesh, my lord. Now, I only want, my lord, this needs to be some regulation control, my lord, by the state only, my lord. Now, in terms of this or in terms of this order, my lord, it is the state constitutional duty to control that, my lord. Now, if my lord will see, my lord will see their epidemic. Indirectly, somewhere they are supporting those violator, my lord. If this is the one affidavit by the respondent number, my lord.
Just a minute. Law provides state, and law has said not applicable, but then the state has issued notification. And then based on that, the case registered, action taken, nothing remains. Okay. By under the circumstances, what prejudice
My lord,
has been caused to
that's why, my lord,
you? What
that's why,
personal or the public prejudice caused by this?
no, my humble submission, my lord, once there is some law, my lord, or once there is some order, my lord, when there is an order, my lord, for the public, my lord, there will be always a judicial, my lord, presumption that, my lord, implementation of that is for the larger public interest, my lord.
No.
My humble submission, my lord. There cannot be, if that law is, there is standing or by the government, my lord.
No, that is why I'm saying. Case registered, police is on action.
Therefore, my lord, kindly, my lord,
Law has been set.
therefore, kindly allow me
on
to,
action.
that way, my lord, whether, my lord,
After that also, what prejudice?
no, my lord, that way, my lord, that way, my lord, my humble submission, my lord.
It is not that no action has been taken.
No, my lord, this action, my lord, is taken when I filed FIL, my lord, when this notice was issued, my lord, just to, I say, my lord, opaque this honorable court notice to the their support to the this whole illegal activity. My lord, kind have a look at page 155, my lord. What they are saying, my lord. I may be able to reach the para 5, my lord, page number. This is by the respondent number 10, my lord. With regard to statement made in para 16, the deponent begged stated at 13:30 hour, written information was received from the petitioner alleging that the Greater Sivansi Badminton organized a lottery on a Tanahari Peace Pond Kola Doimuk. On receipt of information, SI such and such, along with police ready party, Leport Tajuli. However, on arrival to the airport, it was reported to the airport association who was organized a lunch party at this hotel. Is further, therefore, inquiry was made and conduct as per the relevancy of complaint. However, no any suspicious mail. Now, my lord, Tanahari is nearby the police. When there's or evidence
Sir, these facilities, the state has a notification. So wherever they have found violation, even against you, they have proceeded for an inquiry. Let us hope, let us take it that the state is not proceeding police machinery is not proceeding in the manner required. Supreme Court is very clear on this point that if you have any grievance, it is not a PI. It is a proceeding before the concerned jurisdictional chief judicial magistrate. You institute proceedings there. That this is the law, criminal law, which we step to set in motion, but the investigating agency is not proceeding. So for that, PIL is not maintainable. Against you also the same thing. It stopped at a certain point. So the informant therein will not be permitted to come before this court. He will have to go before the BNS section. He'll have to go before the CJN. That famous case of Jharkhand and the Sakari was.
Yes, my lord. That after secretary was my lord, no, my lord, it is not absolute rule. My secretary was absolute. My lord, if my lord find my lord something, my lord, larger public interest, my lord. My only submission here is, my lord, if there is notification, there some place, my lord. Now implementation of those, my lord, will be always in greater public interest, my lord.
We
That
have a
can be
law.
always a
We
judicial
have a law-
presumption on
We
that,
have
my
a
lord.
law which says earlier 302 murder when we lie for this. Is it being not being done?
No, I'm saying
So
implementation.
law
of-
is there. The implementation is not proper. Please go before the appropriate forum. That's what we are trying to really.
Okay. Oh, had Mr. L. Parme, Land Counsel for the petitioner. Also had Mr. S. Tapin, Lanet, Senior Government Advocate for the state.
My lord, before that, I just this one para, my lord, pertaining to this law, who my lord, lottery, my lord, is, my lord, Supreme Court say, my lord, this lottery, my lord, is still in realm of gambling, my lord. Now that need to be somewhere to stop, my lord. There should be some regulation, my lord.
If
I only-
somebody is doing it, the law provides for a remedy.
Fair India 40, sorry, my lord, on 43 and 48, my lord. 40.
That a concerned authority will examine naturally whether it's affected or not. Yeah. Whether it is.
This is again the regulation.
Yes.
Not by the court.
Okay. Hearing concluded. Order is up, huh? Okay.
Obligation.
Item number 4.
Left is madam.
Yes.
Here, madam, I am challenging the judgment dated 22/7/2026, rendered in madam WPC 221 of 2026, madam. This is a transfer matter, my lord. At paragraph, my lord, 47, page 421, my lord. My lord, here the case is, my lord, the petitioner is, my lord, as selection grade officer in the grade of, my lord, Deputy Conservator of Forest, my lord. He was, my lord, initially posted at Rowing, my lord, and was transferred to, my lord, Sagali Forest Division as a DFO, my lord. From there, my lord, he was transferred to, my lord, Bandodo, my lord, Forest Division as a DFO, my lord, by a transfer order dated 14 2024, my lord. And my lord, petitioner joined at Bandodua on 8/11/2024 from Sagali to Bandodua, my lord, transferred, and joined on 13/12/2024 at Bandodua Forest Division as a DFO, my lord. By and transfer, my lord, retention order and modification order dated 24/12/2024, I was, my lord, again retained at, my lord, Sagali, my lord, and in my place, my lord, one, my lord, junior officer, my lord, who was recently promoted to the post of to ACF, my lord, and is on probation, my lord, was posted in my place, my lord. Then I put to, my lord, that transfer order, my lord, modification order before this honorable court in WPC 76 of 2025, my lord, which says, my lord, this honorable court, learned single judge has set aside that, my lord, transfer order, my lord. My lord will find that transfer order, my lord, order of this honorable court at 100, page 158, my lord. My lord, saying that, my lord, I cannot be replaced by an officer, my lord. That too by an, my lord, officer who is on probation, my lord, in a lower grade, my lord. Neither I was posted in his place, so I cannot be replaced, my lord. Then, my lord, after, my lord, that, my lord, I joined and I resumed, my lord, at Bandodua, my lord, by impugned transfer order, my lord, 28/4/2026, my lord. I was again transferred, my lord, midterm transfer, my lord, from the, my lord, office of DFO Bandar Division, my lord, Bandodua Division as a DFO to DCF industry, my lord, by the impugned order, my lord. And again, my lord, in my place, my lord, a person, my lord, my lord, junior officer who was recently promoted to the, my lord, post of DF and on provision was, my lord, posted in my place, my lord. That was, my lord, the ground for challenge, my lord. The ground for challenge was there, my lord. It violates the, my lord, Arunachal Pradesh Forest Service Rules 2019, my lord. Learned single judge, my lord, held in paragraph, my lord, after issuing, my lord, framing issues, my lord, 8 page, my lord, 421, my lord, paragraph 47, my lord. May I read, my lord?
This was also filed by you.
My lord?
This was also filed by you.
My lord.
Okay. Yes. Yes.
Paragraph 47, my lord.
Mm.
The issue which arises for determination in the present writ petition essentially relates to legality of the transfer order and posting of the petitioner from the post of DFO Bandar Forest Division to the office of DCF in the Itanagar and the consequential posting of respondent number 3 and ACF entry grade admittedly on provision as DFO Bandar Forest Division. Paragraph 48. In the present case, the principal contention of the petitioner is that the post of DFO Bandar Forest Division under the scheme of the Arunachal Pradesh Forest Service 2019 is required to be manned by officers belonging to higher cadre, namely senior stroke selection grade, and that an ACF in the entry grade who is still under provision is not eligible to be posted against the duty post. My lord, the findings are, my lord, at, my lord, paragraph 40, my lord, 51, my lord. May I read, my lord?
Yes.
Page 425, my lord. The schedule 1C, my lord, under the rules, my lord, there are schedules, my lord. We are concerned with the schedule 1C, my lord. I will come to the rules, my lord. Provide for the sanction post of additional deputy conservator of forest as attached officer in various forest divisions, including one such post attached to the Bandodua Forest Division. However, the schedule only indicates the cadre strength and distribution of the sanction post under the service. It does not state the post of divisional forest officer Bandodua Forest Division must be held only by an officer belonging to the senior or selection grade, nor does it say that an officer of the entry grade cannot be assigned the functional duties of the DFO, my lord. My lord, will come to, my lord, the schedule, my lord, of the, my lord, the rules, my lord. Page 180, 185, my lord, of the rules, my lord. My lord, before that, my lord, I would like to clarify, my lord, the duty post, my lord, the meaning of the duty post, my lord. At 105 of the rules, my lord. Duty rule to clause G, my lord. Duty post means any post scheduled in the schedule 1, my lord. My lord, will come to schedule 1, my lord, now. At page 184, my lord. These are the schedule posts, my lord. Schedule A post, my lord. At page 184, my lord. Schedule A post are very specific, my lord. These posts are to be held by, my lord, Deputy Conservator of Forest, Administrative Cadre, my lord. And the B, my lord, post under Deputy Conservator of Forest, selection grade, my lord. These are to be specifically held by the selection grade officers, my lord. And, my lord, we are concerned with the post C, category C, my lord, schedule C, my lord, page 185. My lord, the post under, may I read, my lord, C, my lord. Post under additional Deputy Conservator of Forest as attached officer in various forest division as under 19 posts. There are 19 posts, my lord. My lord, the additional Deputy Conservator of Forest has to be, my lord, posted as a attached officer in the various forest division, my lord. We are concerned with the Bandadua Forest Division, my lord. 1, my lord. Additional Deputy Conservator of Forest, Bandadua Division. My lord, kindly see the level, pay level, my level pay, my lord. 11, my lord. My lord, in, my lord, a forest division, my lord, schedule under C, my lord, schedule C, my lord. DFO, there has to be a DFO, my lord, in that divisional forest division, my lord. And in that DFO division, my lord, there has to be, my lord, to assist the DFO, my lord, there has to be, my lord, attached officer, my lord, who is to be, my lord, in the, my lord, grade of additional Deputy Conservator of Forest, having the pay level of 11, my lord. Meaning, my lord, it means, my lord, the attached officer has to be, my lord, in the grade of additional Deputy Conservator of Forest, having pay grade of level 11. And, my lord, DFO has to be made by, my lord, a officer who is, my lord, above the pay grade of, my lord, 11, my lord. He can be, my lord, a selection grade officer, a Deputy Conservator of Forest, my lord. Am I, my lord? Got, my lord.
Level 11. Okay.
Pay level 11, my lord, a attached officer is to be there to assist the, my lord, divisional forest officer in a forest division, my lord. Meaning thereby, my lord, the forest division officer in the forest division has to be of higher grade, my lord. Or a senior officer.
This says that in exigencies,
My lord.
no, this can also be
Yes.
posted.
In exigencies, he can be posted, anyone can be
For
posted,
admin-
but not, already there is an attached officer who is an additional Deputy Conservator of Forest in the Bandadua Forest Division, my lord.
So
Now, my
so
lord,
you mean to say that if the other officers who are eligible, if posted, you have no problem otherwise.
not exactly like that.
Mm.
They're not exactly like that. Because, my lord, what I am saying that, my lord,
Mm.
London Single Judge has said, my lord, there is no embargo to post, my lord, any officer, my lord, even a provisioner can be posted as a divisional forest
yes.
officer, my lord, in a division.
In administrative exigencies. As the department says.
Yes, my lord.
Mm.
But why I am showing this, my lord, there is an attached officer who is in the pay level of 11, my lord.
Mhm.
And the ACF entry grade is enjoying the pay level of 10, my lord. Meaning there were that person, a provisioner who is at pay level of 10 will be, my lord, supervising the attached officer, my lord, who is in the grade of, my lord, additional deputy conservator of forest, my lord. My submission is that, my lord, the DFO has to be in the rank, my lord, including additional deputy conservator of forest, who is senior, my lord, to an additional deputy conservator of forest, or in the selection of an officer in the grade of selection grade.
Okay.
Great, my lord.
After passing this order, what is the status now?
No, my lord, he is continuing, my lord, the respondent, my lord.
He's continuing. And
Yes.
what about the respondent number 3?
Yes, my lord, he is continuing, my
Or
lord.
respondent
I have
number
been
3 is
released.
continuing.
I have been
And you
Released, I have been
What about-
released, my lord.
Hmm?
I have been released. my lord.
released?
Yes, ma'am.
Okay.
My submission is that, my lord.
Yes, then we'll admit it. Let them respond. Let them respond.
My lord,
Let's
because
wait for
I
the
have an
response.
interim period also, my lord, for staying the.
What interim? You are out now. What interim
That
right?
can be reversed, my lord. If my lord stays, my lord, then on a single matter, my lord.
That will be after final
Admittedly,
hearing.
my lord, the findings are
After
erroneous, my lord.
after the response, after their response.
Well, they have already filed the affidavit in the writ petitions, my lord.
Hmm.
Come to page 194.
Hmm. Okay.
Yes.
So,
My lord, this post, my lord,
Hmm.
is earmarked for the, my lord, IFS, my lord, category, my lord. In the rank of deputy conservator of forest, my lord. This is the, for the, my lord, entry grade of the, my IFS, my lord. The deputy conservator of forest is the, my lord, entry grade, my lord. It is reserved for, earmarked for them, my lord.
Okay.
Hmm.
So, now you are out from there means we have not joined the present place of posting.
My lord. I have been released, my lord.
After release, have you joined the present place, your place
My
of posting at
instruction is
Itanagar?
that, my lord, he is on leave, my lord.
On leave?
My lord.
Okay.
And my lord, only, my lord, the question is, my lord, whether, my lord, a, my lord, provisional can be, my lord, posted in a post, my lord, which is, my lord, earmarked for a senior grade officer, my lord. Though, my lord, it is not especially said, but, my lord, attached officer has been given, my lord, there in the schedule, my lord. My lord, initially, my lord, after he was promoted, my lord, only in the month of, my lord, February, my lord. And, my lord, he was, my lord, on promotion, my lord, he was appointed as a attached officer, my lord. Yes, ma'am. Yes, ma'am. And kindly see page 61, my lord. On his promotion, my lord. Page 61, my lord.
Yeah.
He was promoted, my lord, on 25/2/2026 as a, my lord, ACF entry grade, my lord. And on promotion, my lord, as page 61, serial number 2, my lord.
Oh.
The
The
respondent, my lord.
Mhm.
Sri Tapatani ACF was, as a, my lord, transferred to, my lord, as a, my lord, column 4, my lord, attached to the office of DFO Social Forestry Division, Itanagar, my lord. In Bandoroda Forest Division, my lord, there is already a senior officer, my lord, in the, my lord, cadre of, my lord, Assistant Conservator Forest, who was, my lord, who was serving as a attached officer, was also, my lord, recently promoted to the post of additional deputy conservator forest, and he is still continuing as a attached officer, my lord. Lordship will kindly see at page 64, my lord. The present incumbent attached officer. Serial number, my lord, 7, my lord. Manojit Datta, my lord.
21, 1, 20.
And page 66, my lord. On promotion also, he has joined as a attached officer, my lord. Page 66, my lord. May I read, my lord? With reference to the letter cited above, I have resumed my duty at the Divisional Forest Division, Bandalua as ADCF today on dated 1/7/2026, my lord. My lord, a senior officer is an attached officer to a provisioner, my lord, who is a DFO now, by now, my lord.
Okay.
Yes, sir. We'll just,
My-
I think it appears that this requires
Legal
proper
hearing.
consideration.
My lord, just I want to apprise, my lord. Right now in Arunachal Pradesh, my lord, we have 35, my lord, division of forest, my lord, office. And out of that, 21 is marked for, my lord, IFS officers. And out of 21, only 11 IF officers are holding this post because of shortage of IFS officers. Now 10 posts are made by the Arunachal Pradesh Forest Service officers. My lord, this is not the only lone case, my lord. Pasigat also, my lord. Then, my lord, Sagali also, my lord, because of shortage of, my lord, officers. Now, my lord, coming to, my lord, the argument provided by the appellant, my lord. Man, how does he help, my lord? He's pleading for some other else, my lord. My lord, may kindly see, my lord, what he say. That there is already attached officer, right, my lord? But you lord have to see the, my lord, when this man was given, my lord, promotion and the date of, my lord, transfer order is totally different, my lord. After the transfer order of the, my lord, private respondent, then only, my lord, he was given promotion, my lord.
That
Lord,
person is already
just-
a senior officer, my lord. Senior ACF officer, my lord. The
No, no, no.
the incumbent, my lord, who is an attached officer, my lord.
We are talking about, my lord, assistant deputy conservator of forest, my lord, not ACF. Because you have said, my lord, this
He was,
64,
my lord, senior
just a minute, 64, my lord,
conservator of forest. And he
64, my
was,
lord.
while serving as a attached officer, he was again promoted as a additional deputy conservator.
No, you said, my lord, already attached officer was there as a additional deputy conservator of forest, my lord. That is not correct, my lord.
So we have understood
My
properly.
lord.
He says that the cadre is like this, DFO, if AFS cadre,
IFS,
Arunachal Pradesh
forest service, correct, me.
It's a DFO. Then you have an additional deputy conservator of forest, and then you have an AC.
I'm sorry, my DFO is not a color post, my lord, but it's a
No, it's not a cadre.
my lord,
I'm only saying the hierarchy.
hierarchy, my lord, classification of the post, my lord.
Post in the APFS.
My lord.
So you have a DFO, you have an additional deputy conservator of forest, and then you have an ACF. His grievance is why a ACF is replacing a DFO rank officer. And Mr. Dabam, there is already a adjudication depot at page 168 referring to Ibu Tama's case.
Mala, Hibu Tama case is different.
With a resume,
Mala.
but there is a right from a reference here wherein this court had said that this arrangement which was made earlier is bad, interfered with.
Mala.
Now, what is the background you have passed this order at page 100?
Malata, Hibu Tama,
Okay, Hibu.
Mala, now Mala coming to
Right from this, nobody has appealed against this order at page 159.
Mala, there is another judgment passed by the Justice Karaga, similar nature. That is the case of Pasega. Same nature, my lord. If you look, I think they have also mentioned in the other also, my
I'm
lord.
not on that. We are on this point. The judgment will come later on.
My lord.
This court, when he was similarly transferred and an ACF was brought there, the private respondent. was
First case, my lord.
First case.
My lord.
Therein this court said this is not proper.
My lord.
This is illegal.
First case, my lord, there is some communication gap, my lord. Why I'm saying, my
No, I'm not
lord.
on the communication. Yet.
Malak-
There is an order.
There is
of
a
this
order,
order.
there is a order, my
Then
lord.
what made you pass this page 100 order when in the teeth, which was clearly in the teeth of the earlier directions? We'll come to the latest impugned order. But
My lord.
why?
Malak- That order was passed because we could not apprise the honorable court the status of the situation. Number one,
Filed a review or an appeal.
my lord. First, my lord, that the Bandar Division Forest is meant for the IFS officer. Number two, there is a shortage of, my lord, officer. Number three, my lord, he was brought to Bandar Division, my lord, for a special purpose. My lord, number third, my lord. Number third, my lord. My lord, the expect from the division forest officer, my lord. Your lordship knows, my lord, Bandar is very sensitive division, my lord. It's especially for the greenfield and Dorpong region, all
You
this.
have
my
a
lord.
novice ACF to man the post of DFO there.
My lord,
When
Yeah.
you had an experienced hand DFO and there is nothing adverse against the petition, happen
there is.
where you have not disclosed.
My
Have you
lord-
brought up proceedings
my lord-
against him?
It's already, my lord. They challenge the proceeding also, my lord. That also cost, my lord. Department of proceeding is already against him, my lord. They
That is
challenge,
cost.
that was cost, my lord.
That means it's no proceeding. If this
No,
goes.
no, no.
it's cost.
My lord, they challenge the department proceeding. That was, my lord, dismissed, my lord, that petition was.
Or petition.
Yes, my lord, that petition was dismissed, my lord. Now, my lord, yes, you challenge the
But these
department
are not
proceeding.
there in the impugned
Well,
order. These
all-
are not-
My lord, all those things was
No,
not
Mr.
before in
Nawab,
earlier case, my
Mr.
lord.
Nawab, have you questioned the suitability of the petitioner to continue as the DFO of Bandadua?
My lord, if your lordship see the correspondence from the authority.
No,
that
no, in the
indicates-
order, there is no submission also to that effect recorded.
My lord,
In the impugned order, there is no submission to that effect recorded.
but in our affidavit, we have said, my lord,
But in
and
your-
that we have annexed the document also, my lord. He was asked to, my lord, do certain work because of, my lord, rampant, my lord, art cutting and, my lord, felling of trees. There was a complaint before the tribunals, my lord. The department was heckled like anything. So he was asked to look after especially for that purpose, my lord.
He did.
He did not. He failed to just. Now, my lord, coming to my classification, my lord. Now, my lord, coming to these rules, my lord, 2019, my lord. My lord,
So, okay, that, this,
my
I
lord,
think it
just a
takes,
minute, my lord. My lord, my
long,
lord,
Madam,
okay,
1 minute, my
yes,
lord.
please.
My lord, last time, my lord, when my lord, Justice Nair was presiding, my lord, it was informed to the court, my lord, he has been released and he has joined. Now what he's saying, he has not joined, but only, my lord, that is totally different.
That is,
this is my instruction, my lord.
that is his problem.
No, my lord, it's already reflected in page 58, my lord. Sorry, 427, my lord, paragraph 58. No? It's already reflected in the order also. Anyway, my lord. Now, my lord, coming to, my lord, this schedules, my lord. Or, my lord, 2019 rules. The same argument was placed before the single bench. But, my lord, they failed to demonstrate that any, my lord, clause that wherein we have violated, my lord. That's all.
Mm. Okay, we'll fix that, another date for hearing. We'll admit it. Okay. Mr. R. Sakya, Lana Senior Counsel, assisted by Mr. Lana Counsel for the appellant staff. Also had Mr. R.S. Nabam, that is additional AG for the state respondent. Number
1 and 2, my lord.
1 and
3 is private respondent.
and Ms. Duncan
3.
for private respondent number 3, start on para. The appeal is admitted for consideration on the question of the questions raised herein in the appeal, start. Since notice is already issued,
No, no.
okay.
All parties are present, my lord.
Since notice has already been, sorry, since the councils appear and appear on behalf of the respondent, no formal note, and the formal notice is waived, However, the copy you have already received, okay. List the matter on, we'll fix the after
After 2
After 2 weeks.
Because my lord, Justice Ete.
Yes, after that.
After
would be-
2 weeks, my lord.
After
After
2
that
weeks,
will
my lord.
Again, Sanjay, Justice Committee will be here for 2 weeks.
Yeah.
He has come already.
Okay, we have that. Then
My lord,
after,
now things are settled, my lord. Let me inform this court, my lord.
In fact, my lord, there is a division bench order which has rejected the claim of the petitioner in the first Moredi bucket, the one my lord was referring to. That was placed before this honorable court. In another case also of similar nature, it was placed before a single bench.
then it will be all,
But since my lords are just fixing for hearing, I'm not submitting.
Okay.
Otherwise, it is already settled. In the by the
After 2 weeks,
Will also may not say any, least after 2 weeks, my lord.
okay. After 2 weeks, for further consideration, okay. The,
The reported order.
I don't know, I need to check, but it's from this page. Might have been reported. On the question whether or not there can be transfer between different
Cadre,
cadres,
ma'am.
different cadres. Specifically, the question is on that.
Not on for the, not for
Yes.
the probationers, my lord.
No.
Your copy.
Yes.
Just give a copy. So personal come.
Interesting.
the interim also will be considered on that day.
If it is for final hearing, my lord, let my lord.
Okay, fine, yes, okay.
Also may say
In-
file for
My
public
lord, the subject to outcome of the
Okay,
writ appeal, my lord.
The release. Release will be subject to,
My lord.
already released,
He had been already released and joined there,
I
madam.
would
That is the
take-
information we have.
okay,
Release something.
okay, okay, it is submitted that the petitioner has also already been, sorry, the appellant has already been released. Okay, in view of okay, just a minute, the release of the appellant shall be subject to the outcome of this appeal.
I think he's already been released. I will,
No, already released,
yes.
subject to
Fix this
outcome.
topic.
Subject to the outcome.
Hmm. Okay.
Item
Matter
number
after
5.
2 weeks, Okay. Yeah. No,
No, please.
yes,
Mr. Nambu,
Yes, madam.
this, was the ticket that a commission was instituted under the commission of inquiry that
My lord,
it should be,
it should be.
then that report, has it been placed before the legislature?
my lord, for that, they have.
Without placing the legislature, the action taken report, that cannot be utilized or that cannot be given, disclosed in the public.
Yes. My lord, my suggestion is, my lord, it might not be disclosed in public, but it may be, my lord, placed before the honorable court. Instead,
We
my lord.
can also not see. If it is under the Commission of Inquiry Act, the legislature, the cabinet will accept, place it before the legislature subject to correction. Thereafter, it becomes a public document. Till that time, even we can. There is a recent judgment of the Gauhati High Court with regard to the APS system.
My lord, in why this IA has been filed, my lord? Because, my lord, in their affidavit of opposition, my lord, filed by the respondent, my lord. In every sentence, they have used this word, my lord. There is paper leakage. The sanctity of the examination.
Your case is that in the pleadings that have been brought on record, there is no averment that your examination was also cancelled because of the paper. It's a general perception taken and examination. That we will examine.
In that case, my lord. In that case, my lord, if my lord, their argument would be that, my lord, it was in a particular examination, then, my lord, this report may be not necessary, my lord. But as, my lord, they have, my lord, averted that there is a paper leakage. And because of that, our exam was also cancelled.
But there has to be an allegation that in your examination
Yes.
also paper. Yes.
I understand, my lord.
I mean, what do you say? Whether in this examination, there is an allegation of paper.
Your Lordship, because this cancellation has been done by the commission.
Yes, madam, what is?
Lordship, yes. This advertisement was held in the year 2022, Lordship. And the people like fiasco had happened in the 2021, 2022. In the examinations, the person who had conducted the exams was arrested. This exam was also conducted under the same controller of examination law. So we have
Any complaint of the paper leakage in connection with this specific?
no. That's not it. But investigation is still going on. Because in order, after this exam was kept in evidence, in the meantime, after constitution of fresh commission, Your Lordship, we had even written to the CBI to issue us LOC so that we can continue the exams. But in reply to our letter, Your Lordship, the CBI says that investigation is still going on in regard to FAO and TO. So therefore, Your Lordship, we'll have to cancel altogether. Total examinations were cancelled, Your Lordship, inclusive of FAO. Your Lordship.
Between the period 14 and 22,
Lordship.
between the period,
Within the period of 21 and 22, Your Lordship.
okay, 21
All
and
the
20.
examinations which were advertised in the year 21 to 22,
Okay,
all the exams were cancelled.
so this examination falls within this period.
Yes, Your Lordship. During the paper leakage fiasco.
So what is the alternate? Because they have a file RTI also, that was also not allowed. Then it doesn't come under this act inquiry. So what would be the alternate, sir? That's
So,
why
I think
we
this
have
is
to
the
confirm.
Commission of Inquiry Committee.
Lordship, that part also because they file these applications, and I have been given Lordship the report in seal cover, Lordship, and how it has been constituted, Lordship.
Has it been placed before the cabinet? Cabinet has
That also, that part I have.
That I think, no?
This, my lord, page 12 of my IA, my lord. There is order, my lord.
No, we got it.
Yeah.
One man, and whether which is under the Commission of Inquiries Act, that is what, I think it's under the Commission of Inquiries Act. Because a judge has been appointed. I think my subject to correction, I think it should go before the legislature with an action taken report, and thereafter it can be published. You can't also act on without.
So far that process is concerned, since there's no pleadings in the read petition or lawsuit, therefore also if I have not taken the instruction proceed. Only he filed IA seeking lawsuit direction to produce this.
If it is not been seen, if it is commissioned, we should also not treat because it's just a report.
Lawsuit.
Okay, obtain instruction in this regard.
So
Other.
that can be.
Okay. Heard Mr. H. Lampu, line counsel for the applicant. Also heard Miss. And this for respondent number? Okay, Mr. Tapin, line senior government advocate. For respondent number 1 and 2 and
1,
Miss
2, and 4.
1, 2, and 4 and Miss Anju. And Anju for respondent number 3. Stop, At this stage, a question arises as to whether the one-man commission was constituted under the Commission of Inquiry Act 1952. In this regard, the
Not a commission of the Cluster Inquiry Committee, your commission may constitute. That was with what we can see. So it's. Let's check up those APSC cases. Recent. I love justice, who was the. I love the job you.
in which case the appropriate, the government required to lay it before. This is House of Parliament. This is okay. Okay, then in this regard, Mr. Tapin, Line Senior Government Senior Government Advocate, raised for some time to obtain instruction. The prayer is allowed. List the matter after
After a week.
a week. On which date, Mr. Okay, the Line Senior Government Advocates in place. The instruction before this court, huh? Okay. Obliged.
Item number 6.
Nothing is that.
Yes, yes.
Yes, sir.
Let's go.
Kato, what is your?
The instruction, rectified copy was received. Again, there was found some deficiency in the rectified equipment. That also like it's sent back to the authority, now we are on proceed.
Now they have returned that with. They have clarified.
No, we resubmit.
Second time it doesn't
Once-
return. What happened? On 5th, we had undertaken that we'll send it by 5th. On 6th, the executive engineer, he personally, along with the authorities engineer, they went to Tejpur and met the RO, MOT. There they sat together, and they scrutinized that estimate. Then there was some suggestions to be rectified. Therefore, it was again to be reviewed, my lord. That has been now reviewed, and in shortly we will again submit it, because many additional works, the MOT is not agreeing to sanction. The balance work are there, additional works are there. Therefore, what my prayer will be, since these are technical matters, then it will be best if they sit together, the more authorities, the more engineer, the RO, and also the state authorities, if they sit together and finalize it. So that otherwise they will always be shifting here and there, my lord. If they go to the into Delhi, again there might be some objections that might come back. So if there can be a direction from this honorable court that all the concerned authorities, if they finalize, sit together and finalize it, and the approval to be sanction to be approved as early as possible. That would, otherwise every time there will be, these are technical matters, my lord. There may be some
Mr. Ratan, you are trying to project that the technical staff that you have is not adequate.
No, my lord. No, it's not that.
To deal with the small matters.
No, my lord, it's not that. There are additional works which on ground we say that it is required to be constructed. But the more they give objection that we cannot sanction this for these additional works. These are the things.
No, what about the main work?
The main work, the balance remaining main work, that is there.
There,
Plus, even
anything there.
no, madam. Plus the additional, even if the main work is, the balance of the main work
Now,
is
tell me about the, okay, this exercise may go on till ages. But what about the maintenance of it?
my lord,
We have not found any improvement. My lord comes from that side.
my lord,
We have also discussed no improvement.
my lord,
They have shown
my lord,
even disregard to our repeated orders.
my lord, no, my lord, this maintenance was started by the department itself. Now the contractor will, because maybe it's not that so good, the maintenance work, but they have started.
Nothing, they have done nothing. Nothing.
My lord, I have also experienced, I've seen, at least in the
We
ground
are
there.
in very comfortable vehicles. So we feel the problem. Think about the poor citizens.
My
who have to go
lord,
down there.
my lord, works are going.
I think we want your.
Maybe not to the fullest citizen, my lord.
We want them to be here, let them.
My lord, work has
This
been
is not
going on.
going anywhere.
My lord, work has been going on, maybe not to the fullest
We are drawing
satisfaction,
up
maybe.
contempt proceedings against them.
My lord,
Let
no.
them remain in civil
My lord,
prison.
now the proper maintenance that,
I don't know. We only know that the vehicles should go smoothly. How you do it, if that you said you are the technical person, you know it. We passed this order when the notices were issued at the first instance. You did something,
my lord,
but thereafter again deterioration.
my lord, this last week, since the weather also was good, at least some work.
The weather became bad last week. What about before that?
Before that,
They don't see that, or they fly on hovercrafts.
no,
They
my lord,
move around
prior to that,
hovercraft.
it was horrible, my lord. At least.
Nothing is
the-
there. We direct the, we
My lord.
require the chief engineer and your executive engineer, because we had made them personally responsible for that.
My lord,
Let them come here next week, and let them explain.
my lord, works. We have annexed the photographs.
And who is
all.
appearing, your party state also.
Yes, ma'am.
A major accident would have happened in those roads, because I found double parking is going on. Nobody is worried about that. And the vehicles go at a considerable speed. Something happens, a man's life is gone. All area you have built up piers, shortened the length of the roads. Now you have half of the roads occupied by parking of vehicles. Now, how will the citizens move around? You don't have a working footpath. People go along with the roads itself. Some unfortunate incident happens. Who will be responsible? Some money is given, that will end the matter.
But of course, that is the problem. Yes, my lord.
And then this also. Yes. Yes. This also, bring it on the.
Such Mr. P. Panik, Learned Counsel for the petition. Also heard Mr. M. Dauphin, Learned Additional Advocate General, amended group, appearing for the respondent number 1, 2, and 2. Also heard Mr. R. Miller, Learned Standing Counsel for the Public Works Department, bracket highways, and Mr. M. Tapak, Learned PSGI, appearing for the Union of India. This court-wide order dated 4/8/2026, basing on the projections made by the Learned Additional Advocate General, have required the state respondents to submit the revised proposal in the matter before the MOPH authorities. Also, further, this court had passed the following directions. Para 8. But no, para 8 for football. Also, today, when the matter was taken, a status report has been placed, wherein it has been submitted that the revised proposal on being placed before the RTH authorities, certain further deficiencies were found out, and the state authorities are presently working for submission of a revised proposal, which Mr. Ratan on instruction submits would be submitted when
Very soon, my lord, in a day, my lord.
by Tuesday next. Tuesday. So, considering the fact that there has been a considerable delay in placing appropriate materials before the MORTH authorities in connection with the project in question, this code directs that the state authorities of the PWD department,
PWD
highways department, and the MOT authorities to have a joint consultative meeting with regard to the project after a week from the date of submission of the revised proposal by the state PWD bracket highway department. The date of the said meeting be fixed on or before 21/8/2026. So in the said meeting, all the creases be ironed out and the matter be made ready for approval, for grant of due approval by the MORTH authorities. Also, in terms of the directions passed by order dated, passed in para 8 of the order dated 4/8/2026, this court finds that an evasive reply has been An evasive report has been submitted, shifting the blame, shifting the onus to the contractor engaged in the matter. This court widely said order had required the chief engineer, highway zone, PWD, and the executive engineer, Nahal Lagoon's highway division, PWD, to take all requisite steps for maintenance of the road and to make it motorable before the next day of the It is stated at the bar that the set direction has not been complied with. This court had further required the said two authorities to personally monitor the works involved for maintenance of the road. Full stop. The requirement of a motorable road in the area wherein the project is being implemented need not be emphasized. Accordingly, seeing the casual attitude taken in the matter by the said two authorities, this court will be required the authorities to appear in person before this court. Shall we put it on Wednesday, Tuesday? Tuesday? Yes, Tuesday. We don't want to delay. On 18th, 2026 at 10:30 a.m. The said authorities shall come prepared with an action plan for immediate restoration works, for implementation of restoration works to make the road in question motorable at the earliest. Also, restrict to list this matter again on Tuesday as the first item. First item?
In the first paragraph, for the more authorities and the state authorities, the highest, even because here is the regional officer. In Delhi, there is a higher authority. So that highest authority, with the highest authority of the mode.
The date fixing will be fixed by the competent authority of the MORTH.
Highest authority.
We say MORTH, the competent authority of the MORTH.
My submission also may be recorded that I have stated that some work has been
We ignored.
My lord, we have photographed of at least some.
If I put it to vote now,
Yes,
99% would say no.
my lord, from
Except
Papuna,
for him. I don't know
Papuna
where he has seen
Papuna,
that
you
road.
have made it a cemented road. Do you think I don't move around? I also had.
My lord, justice, you come from that side. Paper thin road, black carpeting, there, the paper thin,
Yes.
and what they have done in A sector, I am told, has already broken because of the rains.
It's natural.
It's unbelievable.
See, to state the conditions, we understand. But you have to be on your toes there. You are there. These roads are not for the BWD people. These are for the common citizen.
Our main concern now is we need a road. Otherwise, there needs to be an investigation in this case. Something has gone wrong.
Just emphasize on the come. We are not adverse to anything. We also understand their limitation. But we want to see work on the. That's all.
all right,
With your lordship's permission, I beg to mention item 7, your lordships. Item number 7. Please, your lordship. In item 7, your lordships, on the last occasion, your lordships had directed Union of India to file a counter affidavit. And your lordships, we have received the same yesterday late in the evening. Lordships, I am requesting if the matter may be fixed for the final disposal, your lordships.
Not right. You find your.
No, madam. Madam, the respondent number 2, Ministry of Education, madam. Madam, on the last occasion, madam, we sought for the filing of affidavit, madam. But so far, we have not received the instructions, madam.
You are for?
I'm for UGC, madam. Respondent number 1.
Yeah,
I filed.
Otherwise, also, madam, the issue is between the petitioner and the UGC, madam.
Your lordships, if that is the case, your lordships, because the UGC has filed the counter affidavit. So the Learned Counsel is correct that the issue is between the petitioner and the UGC because we are challenging the
So in
UGC
that case, we are
regulations.
not going to file then.
Please,
Okay.
please, Your Lordships. If the matter may be fixed for final disposal, Your Lordships, I am requesting for a fixed date, Your Lordships. If 31st August or 1st September, Your Lordships, if there is no difficulty.
Okay. 31st is holiday.
The first is
Oh, no. First is holiday.
31st of August, Your Lordships.
it can be on third.
No, yes. Third, so many matter fixed. Then on 8 September. Okay. Third, miss.
Slide.
Why Pallavi? Your Lordship?
Learned Counsel for the petitioner. Also heard Mr. Which for the
For the respondent number 1, my lord.
one, Mr. Kurdu.
El Kurdu, my lord.
Learned Counsel appearing on behalf of standing counsel.
Not standing counsel.
Okay, for respondent number 1.
Right.
And okay. Kato for
Number 2, madam.
2. Okay, Mr. Kato, Learned DSG. DSGI for respondent number 2 and Ms. Wangmo for respondent number 3. Okay, stop, huh? 4 is also there.
That's number 4.
4 is not present.
Lordships, 4 is the Department of Education through Government of Arunachal Pradesh only, which is respondent
Not present.
number 3, State of Arunachal.
Okay, wait, Togum is not present. Okay. Mr. Okay, and Mr. Tagum for respondent number 4.
Represented by Tagum Jamo, madam. It relates to Director Higher and Technical Education.
Oh, higher. Okay, you are
Tagum
for
Jamo. T Jamo is the
Jamo. Okay. The Mr. Jamo who represented respondent number 4 is not present today. Stop. The Lani DSG, Mr. Kato Lani DSG submitted. He is not going to file affidavit in opposition as requested, as prayed earlier. Stop, huh? In view of the above, it is submitted that the matter is ready. Need to be admitted. It's for hearing. We'll fix for hearing.
Yes, yes, Lordships. Pleadings are complete.
Okay, admit. Okay. Since the parties are duly represented and pleadings are complete, the matter is admitted. At least a matter for final hearing on 8 September. Okay.
Deeply obliged. Grateful.
Item number 8.
Well, before my senior brother starts his argument, I want to place a small notification of this Honorable High Court. My lord will have the IA, interlocutory application. No, IA. Well, in terms of notification number 17, Lord, the impugn order has to be included.
We have considered.
No,
We'll take the.
no, my lord, in any, no, my lord, kindly address this issue first. I'm not seeking grace from my lord, but what is there, the Honorable High Court has
You come
not.
to page 53.
No,
You come to page 53 of the appeal report.
whose affidavit?
The present of the, or sorry. Or no, so that is the,
No, my lord is not dealing with this.
to page 90. Of the appeal.
Where is appeal? This is not the appeal.
So, this is the appeal.
Are we Some
So
others-
this is reference.
Yeah,
41,
So page number? Page number?
page number 90.
19.
One.
Okay, okay. My lord is not dealing with this
Your
notification.
Worship.
Because this, my lord, kindly see, it has ramification both administrative and judicial. If this has not been cured, then no interim order can be passed.
Please come to page 19.
It's 19.
19.
19.
Correct, my lord.
Yes, Mr. Tiwari, what is your case?
My lord, I'll just take only 10 minutes and I'll preface my argument, my lord, with the following sentences. Namely, we are here for adjudication. Now, my lord, adjudication is a legal process for resolution of a dispute. Now, what is the dispute? The dispute, my lord, before the London single judge was in respect of the order of the deputy commissioner holding the writ petitioner disqualified. That was the dispute. Now, my lord, what we find is the decision of the London deputy commissioner was totally based on the materials available on record. And those materials available on record point to only one direction and no other direction. And the materials are totally uncontroverted. Therefore, my lord, in such a situation, decision of deputy commissioner, when it is challenged in the writ petition, the grounds are manufactured. Not only the grounds are manufactured, but the one ground is created by London single judge in the interim order. What is the new ground created by London single judge? Namely, raising question on the authority of the learned advocate that he has made an admission. Now, admission itself is based on the materials available on record, which are uncontroverted. So here is a case, my lord.
Where is that? Mr. Tiwari, where is that allegation? Ground?
The
Which
ground, my
paragraph?
lord, in the interim order, my lord will find of the London single judge. I'll take my lord to straight away. Paragraph 11, page 81.
It is not against the government advocate.
It is not against, it is the, my lord, the counsel of the respondent one. Counsel of the respondent one makes an admission. No, admission itself is based on record. Admission is based on the
You mean to say the
materials
counsel-
available on record.
The counsel in the present proceeding, not in the writ petition.
Yes. I'm talking about the counsel who appeared before the deputy commissioner. Now, the London single judge has treated that very admission. London single judge has raised a question on that very admission of the counsel. Now, what we find is the admission of the counsel itself before the deputy commissioner is based on materials available on record, and the materials are uncontroverted. So therefore, my lord, I will now demonstrate not only the interim order creates a ground, but the writ petition itself is based on manufactured grounds. Because apparently, my lord, not a single ground exists, prima facie. Because ultimately, my lord, the interim order has the effect of admitting the writ petition for adjudication. Now, what is to be adjudicated? The nature of the interim order is the admission of the writ petition. The writ petition is admitted for adjudication of the manufactured ground, which itself are not sustainable in law. I allow, my lord, since, my lord, the issue was raised in respect of judgment and the order. It was pointed out yesterday by my esteemed colleague that it is an interim order and the writ appeal lies against the judgment. Now, my lord, the law is well settled since the judgment of the Supreme Court, the full bench judgment of the Supreme Court in Shah Babulal Khibji case, namely, the judgment is to be very, very liberally construed. It has a very wide connotation. even an order can have the effect of the judgment in a given situation. I will only point out two judgments. Two judgments I'll point out. Straight away, Shah Babulal Khumji, the full bench, my lord, was considered by the Supreme Court in Subal Paul case. The entire paragraph is quoted. I hope, my lord, somebody is there from the chamber of my friend Mr. Tafo, and the list of books must have been given. Subal Paul, 2003, 10 SCC.
1 second, sir. 2003.
10 SCC,
Right.
page 361, para 33 and para 34. My lord, if the book is not there, I will, because I told them to give the list of books. I don't know whether they gave it or not. I'll just read para 3 and 34. Whether my lord has got the books.
So timely.
May I read very slowly?
Mr. Tiwari, this is not online, this is art, so it will take some time to come. It will take some time, 2 minutes. We have got it. You can read.
Yes, I just read. Lordship will see para 33 and para 34. I read 33. Shah Babulal Khimji has been quoted with approval. That is in respect of clause 15 of the letters patent, because my lord knows the power of writ appeal flows from clause 15 of the letters patent. Para 33. The Supreme Court in Shah Babulal Khimji case deprecated a very narrow interpretation of the word judgment within the meaning of clause 15. Para 34. Now the entire portion is quoted from Shah Babulal Khimji. This court said, quote, a court is not justified in interpreting a legal term which amounts to a complete distortion of the word judgment, so as to deny appeals even against unjust orders. I repeat, my lord, the word used is unjust orders. In a given situation, when my lord finds that the interim order is unjust, quote unquote, lordship will interfere. Since my lord has got it, I read para 34 again, wherein the Shah Babulal Khimji's portion is quoted. A court is not justified in interpreting a legal term which amounts to a complete distortion of the word judgment, so as to deny appeals even against unjust orders to litigants having genuine grievances, so as to make them scapegoats in the garb of protecting vexatious appeals. In such cases, a just balance must be struck so as to advance the object of the statute and give the desired relief to the litigants if possible. So, my lord, even the unjust order can be the judgment. In any case, my lord, I will show my lord the relevant portion from Shah Babulal Khimji. Now, before I do that, my lord, I have prepared a note and I supplied the note, my lord, this morning to the concerned councils. I do not know, my lord, if anyone is there from Mr. Tafo's chamber. There is a note.
No.
Where do we find?
The note. Where is the note? You
Where
are
is that?
serving us.
There is a small note.
किसको नोट करेगा तू?
Only one copy you gave to the court.
My lord, I'll just read the note for my lord's benefit.
Okay.
I'll read from the note itself.
Mr. Tiwari, give me a second.
Mm.
That's unlimited. Then she gets lost. It's a book. It's the book is a day. Last for the penalty method. Penalty.
Finding.
It's not a limited funding. It's on this. It should not be like. These are before these factors are system. Not even stop.
Memory must be wrong.
But what's up is the all the issues are left. Yes. We have been under no place to get so it's because and once she will be disqualified. But that is again, it's a good idea. It's anything like that. On the other foot, not something of it. The foot will remember, will that is the decision. Only in the
Yes, Mr.
So, my lord, I read from my note for my lord's benefit. I start from para 1. Interim order of London single judge widened the scope of the writ petition by questioning the authority of the learned advocate of the writ petitioner, that is, before the deputy commissioner, to admit those facts which are evident from the materials on record and unequivocally establish the conduct of the writ petitioner of acting against the party whip, thereby attracting disqualification under Section 3(1)(b) of the Arunachal Pradesh Local Authorities Prohibition of Defection Act 2003. This not only goes to the root of the matter, but also has the effect of substantively determining the rights of the parties. Because, my lord, here it is important to note, pausing here, I make it very clear, it is important to note that even the writ petitioner, neither in the representation before the deputy commissioner or in the writ petition, there is a whisper that advocate could not have made such an admission. But in even otherwise, the admission is based on materials on record, which were there before the deputy commissioner. So he was quite candid. He accepted that. Now, what was the material? That is number 2, my lord, I have pointed out. The London single judge ignored the materials on record produced before the deputy commissioner, which established the fact that A, she means, my lord, the writ petitioner. She affixed her signature as proposer on the BJP Gram Panchayat chairperson candidate's nomination paper, thereby actively supporting the opposing party's candidate against the NCP official nominee. B, she cast her vote in favor of the BJP GPC candidate in direct and deliberate violation of the 3-line party whip issued by the NCP. The respondent has herself admitted both facts before this authority, that is deputy commissioner. This was a serious omission which goes to the root of the matter and has the effect of determining the rights of the parties. Then comes, my lord, the next 3. The interim order has the effect of admitting the writ petition for final adjudication as it prima facie finds merit in the petitioner's case where none existed. Now, my lord, we all know what is prima facie case. I need not define for the benefit of a lordship. What is prima facie? If any authority is needed, my lord, I'm just referring to one particular judgment, which unfortunately, my lord, I did not mention in my note. Lordship may have a look, my lord, in Anis versus State, NCT of Delhi, 2024, 15 SCC, page 48, paragraph 50. I repeat, 2024, 15 SCC, page 48, relevant paragraph 50, prima facie. We all know, my lord, in the field of law, what is prima facie. My case is, writ petition did not disclose even a prima facie case. Whereas the interim order records the satisfaction, there is a prima facie case. So I submit, my lord, the interim order is perverse so far as recording of prima facie satisfaction is concerned regarding the grounds. So, my lord, the prima facie satisfaction are totally contrary to records. Such findings are perverse and not only have the effect of causing serious prejudice to the writ appellant, but also has the effect of substantively determining the rights. Non-denial by the petitioner of her conduct of acting against the party whip and of the materials evident from the record, both in the representation to the deputy commissioner and also in her writ petition, amounted to her admission. Overlooking of this basic fact by the learned single judge goes to the root of the merit of the case, thereby substantively determining the rights of the aggrieved party. Now, my lord, pausing here, I clarify that if my lord looks into the representation of the writ petitioner before the deputy commissioner, wherein she has made a prayer for the reconsideration of the order of her disqualification, my lord will find that in the representation itself, the writ petitioner has expressed her grievance that it was she who was earlier nominated by the NCP for the post of chairperson and that she was cheated of that very particular post. So her grievance is against her own party, in fact. She doesn't deny any of those things in the representation. She makes a counter allegation. It was she who was earlier nominated for the post of chairperson. Then comes, my lord, the next. Number 5, finding of learned single judge that the writ petition involves a question of law. Now, this is important. Finding of learned single judge that the writ petition involves a question of law for determination that when Section 6 of the Act, that is below Prohibition of Defection, that Local Authorities Act of 2003, that when Section 6 of the Act lays down the requirement of deciding disqualification proceedings in 30 days, then whether the non-compliance of this mandate would lead to lapse of proceeding, prima facie violates the settled law that the test in such a case is as to who will be prejudiced by non-compliance. That's the point. And Supreme Court has in several pronouncements has repeatedly held in such a situation, the provision would be treated to be directory because it is made for the benefit of the complainant. Complete the proceeding. Same as the scheme of the 10th schedule to the Constitution, providing for decision by the speaker. Because earlier, there was no period for the speaker to decide. So the practice was the speaker would sit over the matter and would not decide the question. So the Supreme Court said, since no period is prescribed, reasonable period, because the entire scheme of 10th schedule is for the benefit of the complainant who makes a complaint. So I just complete this portion. Whether the non-compliance of this mandate would lead to lapse of proceeding, prima facie violates the settled law that the test in such a case is as to who will be prejudiced by non-compliance. Answer to this question is self-evident. Mandate of Section 6 to decide the disqualification proceedings in 30 days is in favor of the complainant. What is meant to favor the complainant cannot be used conversely to favor the offender. You say it is lapse. You are favoring the offender. The very scheme of the act itself, my lord, is negated by such a convoluted interpretation of Section 6 of the act, which is against the settled principle of law. I will cite only 2 judgments for that. What is meant to favor the complainant cannot be used conversely to favor the offender. Such a finding of learned single judge therefore has the effect of reopening the settled law, thereby causing serious prejudice to the complainant appellant. Lordship will see the test which is laid down by Supreme Court in such cases. It is in the case of Saifuddin, which has stood the test of time. That is 1981 SEC, page 403. Relevant paragraph is paragraph 9. If the book is there, my lord, I may read the relevant portion, paragraph 9. I'm sorry if, yes, if the book is there, I'll read. 403. The relevant page, my lord, where the paragraph is, my lord will find page 406. It starts from 406 and concludes at 407. Last line, my lord, of page 406. Whether my lord has got it. I'm reading it, my lord.
No.
Yes,
Where is the other book?
1980. Yes.
I'm reading, my lord, paragraph 9. The difference between a mandatory rule and a directory rule is that while the former must be strictly observed, in the case of the latter, substantial compliance may be sufficient to achieve the object regarding which the rule is enacted. Certain broad propositions which can be deduced from several decisions of courts regarding the rules of construction that should be followed in determining whether a provision of law is directory or mandatory may be summarized thus. The fact that the statute uses the word shall while laying down a duty is not conclusive on the question whether it is mandatory or directory provision. In order to find out, this is important, in order to find out the true character of the legislation, the court has to ascertain the object which the provision of law in question has to subserve. This is important. And its design and the context in which it is enacted. If the object of a law is to be defeated by non-compliance with it, it has to be regarded as mandatory. But when a provision of law relates to the performance of any public duty and the invalidation of any act done in disregard of that provision causes serious prejudice to those for whose benefit it is enacted, and at the same time who have no control over the performance of the duty, such provision should be treated as a directory one, unquote. Now, my lord, here I ask myself a question. For whose benefit the entire scheme of 2003 Act is enacted? It is for the benefit of the complainant. Now, complainant has no control over the performance of duty by the Deputy Commissioner. Complainant makes a complaint regarding disqualification. It is not decided. Imagine a hypothetical situation. It is not decided in 30 days. If it is held, the proceeding would lapse. For whose benefit it would be? It would go to the benefit of the other side. That is not the purpose of the Act. And this is what the law is. It is number one, directory. Number two, it is to be seen for whose benefit the law has been enacted. And my lord, may I point out here, from the interim order of the London single judge, I find, in fact, this submission was made by the other side. That look, it is directory. It is for the benefit of the other side, for the side of the complainant. This was negated, which is against the settled law. My lord, the same principle was reiterated in P.T. Rajan versus T.P.M. Sayer. I have given that citation. I will not repeat the same thing. Now I come to the next proposition, para 6. London single judge also ignored the fact that writ petitioner was expelled from the party on 15/1/26, and she did not challenge her expulsion in any appropriate forum. Till date, expulsion has not been challenged. There is a settled law that the expulsion of a candidate from a party on whose ticket candidate was elected would automatically attract a disqualification from membership. The law to this effect laid down by the Honorable Supreme Court in Ravi S. Nayak and G. Vishwanathan cases, though has been referred to larger bench by the Supreme Court, but the same remain binding on the high courts, and only the Supreme Court is vested with the power to suspend the effect of the law laid down by it on a case-to-case basis. And that is what is being done, my lord. In Amar Singh, it has been reopened, again referred to larger bench, but then, my lord, G. Vishwanathan dicta is binding on your lordship. Supreme Court has a power to suspend its own judgment on a case-to-case basis. The Honorable High Court can't do that. Anyway, my lord, I have given the quoted portions. I will not waste time of the Honorable Court by reading it. Then next, finding of the London single judge on not providing adequate opportunity of hearing to the writ petitioner flies on the face of materials on record, unequivocally establishing the anti-party activities of the writ petitioner, non-denial of the same by the writ petitioner, and admission of the said fact by petitioner's advocate before the Deputy Commissioner. In addition, the period of 12 days from the date of notice for hearing by no stretch of imagination can be called inadequate when the law itself mandates total period of 30 days for deciding the complaint for disqualification. So, my lord, here is a case, lawyer appears, materials are there. Now, I ask myself a question, if now also, my lord, an opportunity of hearing is provided, what is their answer to the materials which are on record, so far as the conduct is concerned? If there is no appropriate explanation, the whole thing would be an empty formality. And in any case, my lord, there is nothing called calculation of the days by arithmetical precision. Total period is 30 days. Within the 30 days period, an exercise is to be carried out. Here, 12 days time was given. What else was needed? Then comes the next. The interim order of London single judge decides a matter of moment and affects vital and valuable right of the complainant appellant, causing grave and irreparable injustice if left unaddressed. Such an interim order would constitute a judgment. Further, its appeal has been held maintainable against interim order that have the effect of deciding substantive rights of the parties. The interim order possesses characteristics of final adjudication affecting the substantive rights of the complainant, such and such. Then, my lord, I have referred to, again, those very judgments which I referred to earlier. Nothing else. So, my lord, this is what the whole case is all about. I simply ask myself a question, where is a prima facie case for admitting the writ petition? If there is no prima facie case, the writ petition is liable to be dismissed.
Yes.
That is all, my lord.
We continue at 2 then.
That's it.
I have also tried drafting some note. It's coming, my lord.
Be helpful.
Yes.
And give him a copy of your.
Yes, my lord, I got it. I got. There is nothing much. There is self-contradiction in his own written argument.
Whether there is nothing, but a young counsel should know
Ah.
that when something is given to the court, it has to be given to the other.
Right,
Okay.
Only for that.
right.
Yes.
Right, but just we can argue. But before I pass on my little note, which I prepared hurriedly, I would seek the grace of their lordship to reiterate my this morning's submission that without complying the notification number 17 of 2023 and notification number 17 2023 without annexing the impugn order to seek prayer for the suspension of the impugn order probably may not go well, because I understand, my lord, this is a notification issued by the High Court after a decision of the full court. So therefore, any decision taken by the full court might have been binding upon this honorable court at large. Therefore, my lord, it has 2 stages. The first stage is it has an administrative consequences, because if the filing section finds that the mandatory compliance of the notification has not been done, there ought to have been a note, my lord. Then, my lord, what I understand from this, because the word mandatory is used there, my lord. There's a word mandatory. When the word mandatory is there, my lord, the compliance is a must. Otherwise, there must be an adjournment of this matter, number 1. Number 2, direct the appellant to cure the defect, my lord.
Take it. Noted.
Yes, my lord. Yes, I pass on this. Only we as a council, my lord, only will have to have the grace of their lordships.
That is,
Whether
need not reiterate.
whether-
It is there from either side.
yes, whether it goes this side or that side. So, my lord, see, these appeals, my lord, kindly permit me public and judicial, precious judicial time, my lord. Now, my lord, these appeal assails a bare interim order of the learned single judge staying the impugn disqualification order dated 28/5/2026. And also, my lord, the appeal itself does not lie. Second, that even if entertained, the threshold for interference is not met. And third, ground by ground, that nothing urged by the appellant justifies disturbing the impugn order. Now, my lord, kindly see in my preliminary objections, my lord, that I am raising, why this appeal does not lie. My lord, the very first question is whether this court should be hearing this appeal at all. For the reasons that, my lord, the order dated 23/6/2026 decides nothing final, my lord. So therefore, the judgment which the senior brother Tiwari sir has relied on the judgment and decree at all will not be applicable in this case. The learned single judge, my lord, has in terms completely left open the evidentiary weight of the admission made by the respondents' counsel before the deputy commissioner, para 11 of the impugn order, my lord, that my lord is seen. Then second, my lord, what has left open? Whether the 30-day period under subsection 2 of the Act of 2003 is directory or mandatory, that is para 11, and listed the writ petition for further hearing after 4 weeks. Now, my lord, these precisely, my lord, the category of the order these honorable courts superior forum has held to be non-appealable, and I rely on this judgment, my lord, Shamshil judgment, my lord. I'll indicate the paragraph. Kindly give this 2023 1 SSC 634. Kindly provide that. My lord, here the proposition is, though any discretion, exercise or routine orders passed by the trial judge in course of the suit may cause some inconveniences or to some extent prejudice to one party or the other, they cannot be treated as a judgment unless they contain the traits and trappings of the finality. So therefore, there is no finality in this order. Everything has been left open, my lord. If such is permitted, the floodgate of appeals would be open, my lord. This is my worry. My lord, thus I have indicated the paragraphs, my lord. I will not read on the authorities. Already I have indicated, my lord. Now, my lord, kindly see, this case derives from Sahab Babulal Khimji versus Jayaben D. Kania, 1981, 4 SCC, page 8, paragraph 56, where this phrase was first coined, and in para 113, my lord, which defines judgment as a formal adjudication which conclusively determines the rights of the parties with regard to all or any of the matters in controversy, my lord. Now, my lord, kindly see an order that expressly reserves the two central controverted questions for final hearing cannot, by definition, conclusively determine anything. I therefore submit with respect that this appeal is premature, in form, and ought not to be entertained. I make this submission without prejudice to, and in addition to, my submission on merits which follow, my lord. Now, kindly see part B, my lord. The standard of interference, even if, my lord, the appeal is entertained. Now, my lord, kindly see, assuming, my lord, for the sake of argument, that this court proceeds to hear the appeal on merits, the threshold of interference with the discretionary interlocutory orders remain narrow, my lord. On a thin edge of a sword, my lord, is like, my lord, is like the English idiom, my lord, or the phrase per se, my lord, the Damocles sword hanging on the head, it might fall anytime, my lord. So therefore, it is paddled on the narrow, very narrow strip, my lord. My lord, I rely on Wanderland, my lord. Wanderland, my lord, para 9 and 14, my lord. Here, my lord, the proposition that the appellate court will not interfere with the exercise of discretion of the court of first instance and substitute its own discretion except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court had ignored the settled principle of law, my lord. Therefore, my lord, here everything has been left open by the learned single judge in the impugned order, meaning thereby, my lord, they could have filed affidavit in opposition in the single in that matter and argue the matter and conclude there. What is the necessity of filing a writ appeal? It implies, my lord, there are certain personal differences or personal grudge between the parties, my lord. So therefore, my lord, on the ground of a personal grudge, the precious judicial and public time of this honorable court should not be allowed to such litigant. So that is my conclusive point, my lord. I will now take your lordship's through each of the appellant's ground, my lord. Because since my lord have already entered into and demonstrated that none meets this standard. My lord, kindly see ground by ground rebuttal, which I am giving is ground 1 and 2, my lord. Necessary consequences of expulsion, which my senior colleague made a submission to this extent. My lord, see, these grounds attack a question of learned single judge never decided, my lord. Kindly see, my lord. The argument which they have advanced and the ground they have pleaded, which has never been decided by the learned single judge. The appellant's own list of deaths, my lord. Kindly see. The appellant's own list of dates records what he calls as issue number 1, that this question whether expulsion automatically entails disqualification was not considered by the single judge at the interim stage. There is, in law, nothing here for this court to find erroneous because nothing was decided either way. These grounds belong, if at all, to the final hearing of the writ petition and are premature before this bench, my lord. Now, ground number 3, 4, and 5, my lord, that is which they have pleaded is a 30-day and 24 hours, my lord. Timeline is mandatory or directory, my lord. The purpose, my lord, what I understand is, if the statute provides you to do certain things in a certain manner, you must do according to the statute what it has provided and mandated you to do so. Here is a case, my lord, very interesting, my lord. Kindly see it. The appellants lean on, my lord, which they have relied on this judgment. I am negating this. UP versus Singara Singh, my lord, very old judgment, my lord. Singara Singh, my lord. AIR 1964 SC, my lord. 358, para 7 and 8, my lord. For the proposition that where a statutes prescribe the manner of exercising a power, that manner is exclusive. My lords, that principle governs the mode of exercising a power. It does not, without more, convert every attached time limit into a jurisdictional bar. And I rely on, my lord, on this, my lord, on these timelines, my lord, specifically, the governing test is one of the legislative purpose, which senior brother was also referring to. P.T. Rajan, my lord, I am referring to 2003-8 SSC 498, my lord, that is indicated in my note, my lord. I have checked the citations and verified, my lord. 45 and 47. And these proposition was followed in Chandrika Prasad Yadav versus State of Bihar, 2004, 6 SSC 331, para 31. The question was whether a provision is directory or mandatory would not depend upon the phraseology used therein, but on the purpose and object the statute seeks to achieve. And the interpretation was, it is not a mandatory. These kind of interpretations, my lord, might have ramifications in discourse of a judicial proceedings, my lord. Now, kindly come, my lord, I have given my interpretation for section 6, subsection 2 of the Act of 2003, my lord. Prescribes no consequences whatsoever for delay in decision. Where a statute is silent on the consequences, these courts' own precedents leans towards treating the provision as directory intended to secure expedition, not to extinguish jurisdiction. This precisely why learned single judge quite correctly, my lord, declined to decide this question either way and left it open for detailed deliberation at the final hearing. Let us apply our mind together, my lord, because while reading this, while preparing, I find it. It follows that, my lord, ground 5 is strictly not a ground against the interim order at all, my lord. Kindly have his ground 5, my lord. It is strictly not a ground against the interim order at all, my lord. It is a ground against an issue that court has not yet decided. Where is the question of fait accompli, my lord? There is no fait accompli at all. No decision has been taken. Ground number 6, my lord, I will be very precise, my lord. So, now, my lord, kindly see the ground number 6, which they say, Deputy Commissioner bound by CPC as a quasi-judicial tribunal relies on Ravi Naik and Rajendra Singh Rana. my lord, this is the senior counsel has relied para 11, but I'm relying para 11, 18, and 20 as well, my lord. Now, kindly see, my lords, the very authorities relied by the appellant defeat this ground. Ravi S. Naik versus Union of India, 1994 supply to SC 641, para 11, 18, and 20. Upheld a disqualification proceeding conducted on a summary procedure, not a full CPC trial, framed issues and written statement. The appellant cannot invoke Ravi Naik for a proposition it does not support. I'm giving the answer correct. Next paragraph. What Ravi Naik and Kihoto Holohon, my lord, that paragraph 109 and 11, my lord, do insist upon is that the proceeding be free of mala fides, perversity, and violation of natural justice. That is exactly the finding the learned single judge has made. Prima facie, my lord, word prima facie. The authority was relied on, where is that? Tiwari sir's note. My lord, that judgment on the prima facie 2024, I think, sir, has relied on. Anyway. In the respondent's favor, my lord, in fact, it is in my favor. Not a complaint about missing CPC formality, but a finding that a first and only request for time to file objection was refused outright, my lord. Kindly see, my lord, at least for a fair trial, my lord. Article 21 speaks, my lord. Even if a person is a hardcore criminal or the terrorist, he deserves that basic human rights under Article 21, my lord. The facet of 21 itself is very large and wider, my lord. But, but a finding favors not a complaint about missing CPC formality, but a finding that a first and only request for time to file objection was refused outright, and the matter closed the same day, my lord. Kindly see. The matter was closed on the same day. The ground 6, properly read, my lord, kindly see ground 6 of the writ appeal, my lord, supports the impugned order rather than undermining it. That is what I would respectfully submit, my lord. Now, my lord, kindly see 7. I am using, my lord, that Whirlpool Corporation judgment, very popular, my lord, audio altrum paltum, my lord, reliance on Whirlpool Corporation, my lord. Para 14 and 15, my lord, which I am relying on the proposition that a writ under Article 226 is maintainable despite an alternative remedy where there is a violation of natural justice. Because the learned senior brother has heavily harped on that in this qualification, natural justice will not be applicable, my lord. But to my understanding, I respectfully beg to defer that submission, my lord. Natural justice or the proceeding is wholly without jurisdiction, my lord. Kindly see. My lords, this authority justifies the maintainability of the writ petition itself. That's what I am formulating, my lord. Is maintainability of the writ petition itself. It does nothing to show that natural justice was, in fact, observed. The appellant has cited authority for why writ court was right to entertain the petition, not for the stay was wrong, my lord. I have never raised this issue, my lord. On substance, my lord, kindly see on substance, my lord. That next, I have another one more page to go. On substance, notice was issued on 22/4/2026, my lord. Hearing fixed on 4/5/26. 12 days later, on the very first day of appearance, a request for time to file written objections and rebuttal document was made and refused. And the matter concluded the same day. This is not a case of a litigant seeking indefinite adjournment, my lord. It is a first request refused outright in a proceedings carrying the gravest civil consequences and seating a democratically elected representative. The prima facie finding of the learned single judge on this specific and undisputed fact cannot be said to be arbitrary, capricious, or perverse under the Vander standard, my lord. Now, one more page to go, my lord. Procedural, double standard, and colorable exercise. The reliance on Umanath Pandey by the appellant. My lord, kindly see, to 2009-12 SSC, page 40. Natural justice is another name for common sense justice, para 3, my lord, and must be precise, unambiguous, and afford adequate time, para 8, my lord. Here, my lord has seen already, I was not given a day even, my lord, to hesitate. And the crucial question is whether prejudice has resulted from the breach, para 7. Because you conclude the hearing on the same day and pronounce the judgment. When I sought a time, my lord, to file my counter, my lord, kindly, their lordship, ask ourselves, is this justified? It is nothing but a tyranny, my lord. It is nothing but the action of a tyranny, my lord. Well, there is an English saying, my lord, I walked yesterday, I walk today, I will walk tomorrow. You cannot have all these niceties with you. You cannot, my lord. So therefore, on these premises only, the writ appeal should be dismissed, my lord. My lord, kindly see this authority too supports the respondent. The appellant's own pleaded facts show months of latitude extended to the complainant and the member secretary 28 days, delay in forwarding 89 days, my lord. Kindly see what the rule says, 48 hours and 30 days, my lord. So therefore, my lord, is aware, this anti-defection law is pari materia to the 10th schedule of the Constitution of India. But here, the conduct itself can infer the disqualification of an elected member. But, my lord, we are not on this pedestal today, my lord. The writ petition has been structured and filed on the basis of a violation of the procedural aspect, my lord. My lord is aware that Suresh Desai judgment in the 10th schedule, my lord, Desai 23, my lord, that's judgment, my lord. Now it works on two pedestals, my lord. The first is majority of the legislature can march, but if not supported by the political party. So then the merger has to be in consonance with 2 points, my lord. It should be supported by the political party. Now, legislature cannot. And my lord, therefore, the Supreme Court is in session of the matter. The Kapil Sibal versus Union of India, my lord. There is an argument going on for the last 7 days, my lord. It is likely to be concluded shortly, my lord. Once there, the argument which Sibal sir has adopted is unless the political parties do not merge along with the elected leaders, the merger will be illegal. Umbilical code. Umbilical code. The umbilical code. No, my lord, kindly see, my lord, this authority which I have referred to, the Umanath Pandey judgment, my lord, this authority to suppose the respondent, the appellant's own pleaded facts shows month of latitude extended to the complainant and member secretary, 28 days delay in forwarding, 89 days before hearing was fixed, set a single request for a short adjournment, refuse outright on the first date. This asymmetry is the very foundation of prima facie natural justice finding, my lord. It is, as the appellant suggests, an argument against it, my lord. But only one more page left, my lord. Ground 9. The argument has so been advanced, my lord, non-speaking order, my lord. And the reliance was made on Kranti Associates, my lord. Now, what this Kranti Associates says, my lord, 2010 9 SSC 496, para 7, on the duty to record reasons in quasi-judicial proceedings. My lord, this ground, even taken at its highest, my lord, is an argument for why the final relief in the writ petition should succeed. It says nothing about why the interim stay pending, that determination was wrongly granted. The appellant conflates a ground for final relief, which a ground against an interim order. They are analytically distinct, my lord, and this appeal is confined to the latter, my lord. Now, I am almost concluding, my lord. Now, the definition of the word fraud has been pressed in the argument by the senior counsel this morning, my lord. My lord, it is a settled position of law that fraud vitiates everything. It is not a case of fraud, my lord. My lord, kindly have annexure 1 of the read petition, my lord. No, annexure 1 of the read petition. There, no, read, appeal में कितने? My lord, just I give. No. That annexure 1 in the read petition I wanted.
This one is 57. It's 57.
Kindly see, my lord, which they say there's something very different, my lord. 58, my lord, SOCAS notice. We have not received anything, my lord. And annexure 5 shows, my lord, the same letter dated 31. No, annexure 1 they have appended. My lord. In the annexure 1 they have appended, my lord, 03/1/2026. While the appellant's own annexure 5, my lord, shows the same letter dated 31/01/2026. Now, who has committed fraud? It is by them, not by me, my lord. And this poor lady, you have some grace. Now, see, this discrepancy appearing on the face of record filed by the appellant himself is precisely why such a serious allegation must await examination of the original record at final hearing, my lord. It cannot found interference with interim order today, my lord. My lord, I am not relying on because that was on the limitation whether, but this is one of the landmark judgment, my lord. In Arunachal, Justice Nani was on the other side, and who was the other one against whom lost? So that judgment, my lord, whether the law of limitation will be applicable or not in special laws, my lord. So law has been settled here, section 27, 29, it will be applicable. So therefore, my lord, when this judgment, when I relied on, my lord, obviously it will have implications on them. You cannot, why these 28 days, 69 days, my lord? My lord, the last ground 12, my lord, I am finishing, my lord. Ground 12. Complaint by an illegal lacking authority under NCP's Article 32. My lord, I am extremely sorry, my lord. I have only one copy of this thing. My lord, will kindly see this. Who are this man is not, my lord. The appellant is not authorized by the NCP constitution, my lord. From where he has drawn the power. And nothing is shown in the read appeal also, my lord. Kindly have this. My lord, kindly bear with me. I'm so sorry to have not printed this.
Is this a ground?
Yes. Because we have made it. No. We have made a specific ground. No, read petition. But I will just help it. Okay. My lord, kindly page 31. 31 of the appeal. I made it categorical statement that it is categorically stated that the letter dated 03/01/26 bearing so and so addressed to the member secretary 04 Pistana ZPM constituency Key Panir, district Arunachal Pradesh, written by Neelam Sanjay, vice president admin, chairman, the disciplinary action committee NCP. He is a man from block, my lord. Meaning thereby entire process has been vitiated, my lord. Key Panel District, Arunachal Pradesh has been issued in violation of Article 32, Discipline of the Constitution of National Congress Party, which prescribes the modalities for initiating disciplinary action against any active primary member or elected member of the party. My lord, the German. That goes to the root of entire case. Why this qualification petition itself is vitiated, my lord. This has been filed out of vengeance, my lord. He do not have the power, my lord. A person who do not have the power cannot institute a suit, my lord. That is, my lord, will see this section 6 of the CPC, my lord. And we filed a suit in section 9 and 21, my lord, of the CPC. So therefore, these are the grounds where we are, my lord. Now, my lord, I am concluding with this, my lord. This raises a fresh question concerning the internal disciplinary architecture of a political party. Whether respondent number 4 had the authority under the party's own constitution to initiate authority under the party's own constitution to initiate the complaint. My lord, the answer, this was not the basis of the interim order, was not the subject of the finding under challenge, and requires its own factual inquiry, my lord. It cannot, therefore, demonstrate that the discretion to grant interim leave was exercised arbitrarily, capricious, or perversely. The only basis on which the wonder permits interference, my lord. I conclude with a grace, my lord.
Sir,
My lord.
kindly go through your paragraph numbers in the. No, you have maybe
Yes.
hurriedly done it.
Yes.
Because in Umanat Pandey, I don't find para 3, para
It-
6 is not.
No, no, my lord, but this para 3, there, para 3, you will see, para 3, it contains.
Para 3, 6 is not there.
My lord, 7 is there. Sir, my lord, it is there. I remember I read through that. Para 3, after para 3, my lord will see. 6, 7, 8.
3 is the quoting.
Quoting, yes. Those judgment I rely. That's paragraph I rely. Amarnath Pandey.
Check up.
I'll check up, but these are the correct.
Fresh note.
Yes. So therefore, my lord, the sum and substance is that the first thing I urge, my lord, is that non-compliance of the notification number 17 itself is a ground for dismissal of this writ appeal, my lord. Secondly, all the issues which they have raised and pleaded are left open by the honorable single bench. So therefore, there is no reasons or the ground assigned by them plausibly, my lord, for a kind interference of this honorable court. I'm grateful, my lord.
Mr. Tara,
My lord.
one clarification.
Correct.
What is the purport of section 10, schedule 10? And act
Where is
like
that?
the 2017, what is the purport?
Act. You know, act.
No, just the purport. What is the purport for section schedule 10 of the constitution?
Correct.
And an act of 2007, like act of 2017. What is
Correct.
it? What is the intention? What is the purport?
Well, the intent and objective was basically to stop the defection. Because if a political party set out Mr. A as a candidate, you elect, and thereafter there are certain political developments, you ditch the political party. To stop, to bring an end to this defection, my lord. Because the under 10 schedule, my lord, what the national political parties are doing, they are taking another route, my lord. They said, no, that political party merger is not required along with the elected legislatures, my lord. That's why, my lord, that Rajendra Singh Rana judgment, my lord, two-hat theory. It says, my lord, the MLA is responsible inside the house, and anything he does under the assembly hall is protected under Article 212 of the Constitution. Privilege he grants, my lord. And that is, my lord, in Arunachal Assembly rule, I remember it is 301, the rules they have. And here, my lord, the political parties. So then, without the merger of the political parties.
Another when a matter of disqualification comes up with your both of exercising jurisdiction like us, two questions. Whether we should go to the meat of the matter to say, like in this act of the state, 3-1, should we examine that whether 3-1 is attracted, or we should be in the periphery?
No,
or we go to the meat of the matter and see whether 3-1 is attractive.
The root of the disqualification itself is 3-1.
3-1. So, an approach this court should take. As a senior counsel, I'm asking you.
Yes.
When a matter of this nature comes before us, because it comes normally, should we look into the periphery or go into the matter to understand whether 3-1 is attractive or not in the first instance? which is the part to be proved.
My lord, it depends on fact to fact.
No,
Fact to fact.
not on this case. I'm on a general appreciation theory.
Appreciation would be the root is 3-1. 3-1, my lord. That I cannot mislead this.
No, that's why we
Then
asked you.
number 2, my lord.
And this will not be used against you, don't worry.
And my lord, kindly see the Kyoto Holohon. There are 100 and 111. My lord. What happens is, my lord, whenever the speaker sits on the disqualification petition, he functions as a quasi-judicial. That is tribunal, my lord. So once a person, my lord, here, my lord, in this case also, under 6, my lord, under section 6, my lord, if the deputy commissioner is sitting on the disqualification petition, his role is a quasi-judicial body, being a tribunal. So therefore, the spirit of my lord, what happens is in 226 proceedings, my lord, I've seen that there is one section in the CPC, section 141 of the CPC, my lord. Kindly see that spirit will be followed in the proceedings, my lord. So similarly, even if the spirit is taken on this count, my lord, the deputy commissioner ought have to give an audience, my lord. At least for a day, you adjourn, you come and explain. That much, my lord.
My lord, I appear for the state, my lord.
Yes.
Yes.
My lord, the undisputed fact is that the respondent herein, he stood as a proposer for the BJP candidate, despite she being a NCP Gram Panchayat member. She was the proposer for the Gram chairperson candidate of BJP candidate. This fact is not disputed. This has been admitted by the respondent's counsel before the deputy commissioner. In the entire writ petition, there is no averment saying that I have not stood as a proposer for the BJP candidate. In the entire writ petition, there is no averment, nor in her representation. There is no averment saying that, no, I have never stood as a proposer. No averment anywhere. Nor even the averment that I did not ask my counsel to admit this. In the writ petition, there is no averment that my counsel was not authorized to answer, say this. There is no averment. The entire writ petition is on the premises that the time has lapsed. After the given time frame, the deputy commissioners could not have taken up this complaint and decided. Now, but the fact which is admitted, not disputed, is that the respondent stood as a proposer. And that is on record, because a proposer has to sign for the candidate. She cannot even retract his being a proposer, her being a proposer, because the person who is whom she proposed, if she says that I was not the proposer, her chairperson will go. That is obvious. So now she cannot. Now the crux comes here, whether being a proposer is sufficient. It infers that she has voluntarily given up the party. This is not a case of either merger that I have voluntary giving up of party. 3-1. Split is normal. Not even 3B, 1B, not even that. Simple case of voluntary giving up of party. Once she becomes a proposer for the rival candidate. That itself infers. To that, my lord, there is already a settled division bench, similar facts and circumstances of our own Gauhati High Court, where my learned senior Tiwari sir himself appeared for the appellants. This is 2012 4 GLT 1108 division bench judgment. My lord, I'll just in short the facts, my lord, in page 2. First is the Panchayat election was held in the year 2008 in the state of Arunachal Pradesh. The appellants were elected on Indian National Congress in shorts INC ticket as Anshal Samiti members and Gram Panchayat members, so and so, of various Gram Panchayat under falling under 16 Yacholi ST Assembly constituency. Their term being for 5 years would expire on so and so. Then for 16 Yachuli ST Assembly constituency, 3 candidates filed nomination papers, one of whom was from All India Trinamool Congress, AITMC, and another was from the INC. In the nomination paper filed by the candidate of AITMC, the appellants acted as proposers within the meaning of Section 33 of the Representation of People's Act 1951. This is the fact. Immediately after the polling, all this disciplinary proceedings complaint was initiated. Then, my lord, I will not bother much, my lord. Para 19. Para 19, my lord. In the present case, the solitary instance of the appellants becoming the proposers of the AITMC candidate was sufficient to give rise to a reasonable inference that the appellants had indeed given up the membership of their own party. Otherwise, they could not have become the proposer of the AITMC candidate, party. And thereafter, I'll not read the entire. The requirement
right? What is the
the requirement for even giving an opportunity, what would have the be the consequences when the facts are straight? Had he made out a case that had I been given an opportunity, I would have proved this. I would have proved that. No, but the fact remains established. Para 22 also, my lord. While dealing with the above aspect of the case, it needs to be noted that the question is not whether there is a series of acts or a single act. Rather, the question is as to whether the act done give rise to the reasonable interference that membership of a party has been voluntarily given up by the appellants. In the background of the discussions held above, one cannot but conclude that the appellants were clearly proved to have, by becoming the proposers of AITMC candidate, acted against the official nominee of the INC, and they wanted, in the absence of anything showing to the contrary, that the AITMC candidate to win and the official candidate of the INC to lose, and the appellants could not have succeeded in achieving except in voluntarily giving up the membership of the INC. So the other this argument that the person who made the complaint was not authorized, he was not he could not have made the complaint. That all, my lord, that was never raised before even the deputy commissioner or the single.
But it was there in the.
I'm sorry,
Yes.
I'm sorry to interrupt, my lord. Just a simple clarification. This is an issue
Yes.
to be decided by the civil court as to whether or not constitution of a party gives competent to X, Y, or Z in a matter of initiating disqualification proceeding or passing an order of expulsion is purely a matter for civil court. Constitution of a party, we deal with the civil court. It is not for the honorable court under 226 jurisdiction. My lord, I'm just aiding, my lord, my esteemed colleague
Okay.
from the state of AP.
Very good. Yeah. Okay.
All that.
Third, Mr. P.K. Tiwari, Land Senior Counsel,
I'll not at the full one will be relevant.
assisted by Iminjo, Land Counsel for the appellant. Stop. We've also heard Mr.
Is case to disclose.
Who comes first? Yes, N. Ratan, Learned Additional AG for the state respondent number 1.
In the appeal. On 4, 2, 2, 3, and 4.
In the appeal, 2, 3, and 4.
Yes, one will be by Mr.
Okay,
One is the private aspect.
one is for, one is
by-
repeat.
One is by Mr. Tara.
Okay, this is appeal. Okay. Mr. Titi Tara, huh?
We would want the appeals.
Also heard Mr. Titi Tara, Learned Senior Counsel, assisted by
Enyama.
Learned Counsel for appearing on behalf of the respondent number 1.
Act.
And Mr. N. Ratan, Learned Additional AG for the respondent number 2 and 3.
3 and 4.
2, 3, and 4.
We have at home. Just give it.
In the appeal. Just a minute. Huh?
This we have at home.
Is the respondent number correct?
No. NCP constitution, there's also.
Yes.
Okay.
Okay.
I'll forward you.
Hearing concluded,
I'll forward you.
judgment reserved. Huh?
I'll keep this. I'll forward you the act.
No, we don't. Just give me the 11.
That's fine.
I increase my volume.
My lord, I take,
My lord.
my lord, I take leave.
Thank
I
you.
take leave, my lord. Before parting,
Yes,
just only
judgment
one.
reserved.
Before parting, only one sentence. Procedure is the handmaiden of justice. Nothing more.
And the father no more bully.
Much
We are grateful.
Item number 9.
Nine up to 15, my lord. It's arising out of
Just a minute. Okay.
same judgment, my lord, for application, my lord, referring for delay of condoning delay of 232 days in
Who is the
filing.
notice?
My lord, notice, my lord.
Okay. Heard Mr. Tidagum, Learned Counsel for the applicant stuff. This is an application filed under Section 5 of the Limitation Act 1963, seeking condonation of delay of 232 days in preferring the accompanying appeal against the judgment and order dated 2011-2025, passed in the WPC number 35/2024. This one notice. returnable by 4 weeks. Stop. The petitioner shall take steps for service of notice upon the respondent by speed post as well as by usual process within a week from today. Stop. List matter after 4 weeks. Okay, it's all the same.
Yes, same, my lord. Only
Yes.
petition number, my lord.
Mr. Pratham,
My lord.
the only reason why these people after their termination was not accommodated as a
My lord.
server shiksha
My lord.
is that your case is that after they were regularized,
My lord.
those posts as per a policy decision of the government is
My lord. That is one of my lord. One of but as of now, where our stand is, my lord, there's no existing post, my lord, because post has to be sanctioned by the central government.
no, no.
Now,
Here, this situation is these people, you have got no allegation against them with regards to their appointment in service.
my lord, my lord,
Why have they not been brought back here?
my lord, reason being, in service shiksha, my lord, the appointment made annually, my lord. Even
I know that, but
My-
these people, you had taken them as
My-
regularized employees. We
My-
can finish up the matter
my
today
lord,
itself.
my lord, regulation has not been done by the
Because
parliament.
that ground will not apply to these people.
My lord, regulation, my lord, that has not been done. My lord, my respectful submission, this age of now, because
Don't they delay and dismiss the petition.
my lord, there's altogether, my lord, my respectful submission, my lord. There is no sanction post, my lord. That's why, my lord.
Mr. Kagum, your policy is once you are regularized, your post in service shiksha will be deleted or vacated. Now these
But in
people,
case of regular, my lord,
service shiksha is never regular.
no, my lord, in case if the post, it is regularized, my lord, the post they're holding, that will be abolished. But
here-
in this case, my lord, their post has not been continued, my lord.
No, that is the problem. You would have to take a review. You would have to review
My lord,
it.
that is why, my lord, that is the government of India. Now, government of India, they are winding up the project, my lord.
So you have no issue if they come back.
Yes, if the government of India,
So
if
what
they,
we do is we'll condone the delay, admit the appeal and dismiss the appeal, saying that you carry out a review exercise.
my lord, from the department side, my lord, we tried, my lord, saying that there's no back end.
If that is the thing, let those poor people come back. They were serving as teachers. You have got no grievance against them. If you agree to that, we do that. Subject to.
My lord, let notice go, my lord. Because, my lord, in fact, my lord, that's the state of the government, my lord.
Okay, let me.
So,
All the same.
9 to 50.
9 to
9 to
only
9 to
only
15.
case numbers, my lord. Out of
Okay.
same judgment, or
All
case
case
numbers
number, huh?
different, my lord.
Hmm.
My lord.
Item number 16.
So. Mhm.
Lordship,
Yes.
in this matter, fixed date may be given, Lordship.
Okay.
Mr.
Presume that we will not.
No, Lordship, due to some emergency, Mr. Kato had to leave the court.
In that case, Lordship, on coming Thursday, 20.
Hmm.
Yes. But this, I'm not what this person. Still want to government to be here for record. But that means people of the future. This the issue of whatever. The participate.
Mhm.
Get it. Learn something that.
Mhm. Okay. Ms. Gao, Planning Council 4, Planning Council appearing on behalf of Mr. M. Kato, Lane DSGI. No. Ms. Gao, Lane Council submits that Mr. Kato, Lane DSGI, who represent the respondent, has some personal difficulties. Therefore, she prays for adjournment of the matter for the day, to which Mr. Ndangan, Lane Council appearing for the appellant has no objection. Prayer allowed is requested. Come on, list the matter on
20, next, coming Thursday.
okay.
Of
20.
My lord, I may be please allowed to this mention item number 8, my lord, for the day. This may be fixed after 2 weeks, my lord. I have taken consent from the petitioner. I am representing this respondent number 1, 2, and 6, my lord.
1, 2, and
6, my lord.
6. Okay.
I have taken consent from the this petitioner counsel, Mr. D.K. Pangan,
Okay.
my lord.
Mr. T. Jamo, learned counsel appearing on behalf of the respondent number 1, 2, and 6. With the
Six, I am, madam, I am.
No, my lord, he's mistaken.
you are for 1 and 2.
No, 1, 2, and respondent 6. He's this confusing it with the
Okay.
item, my lord.
With the consent of the learned counsel appearing on behalf of the petitioner. Pray for listing this matter
After 2 weeks, my lord.
after 2 weeks. The prayer is allowed. List the matter accordingly.
I beg to mention item number 11 here also. This matter to be listed on 10/9/2026.
When?
In this matter, your lordship, for respondent number 4, we have already filed our counter affidavit.
Okay.
But for respondent number 2, 3, and 5, we are yet to receive our paragraphs. So, your lordship,
Okay. Who is for the petitioner?
yeah, I have informed your lordship.
Have you informed?
Yes, sir, lordship.
Informed.
Yes, sir, lordship.
Okay. Ms. Pango, Learned Government Advocate, submits that the state has filed affidavit in respect of the respondent number 4. However, she is yet to receive instruction in respect of respondent number 2, 3, and 5. Therefore, she prays for further how much time?
Your lordship, matter to be listed on 10th of September, your lordship.
Okay. I will pray for adjournment, praise for granting time and to be listed on 10th of
September, your lordship.
September. Why?
The petitioner asked me to
Okay.
date.
Okay, she has also, okay, she has also obtained consent from the counsel for the petitioner who requested her to get the matter fixed on 10th September. Accordingly, let this matter be listed on 10th September. Okay.
Madam, I beg to mention item number 3 to 6, madam. 3, 4, 5, and 6, madam. Madam, can this matter be listed after 3 weeks, madam? My lord, I've taken consent from the other party. This, basically, my lord, this, they're challenging the reversion order pursuant to the order passed earlier in the, by the coordinate bench, madam. And that judgment is under challenge, is pending, writ appeal is pending. That's why it's subject, it's ultimately, it's depend upon the outcome of the writ appeal pending for division bench. That's why, madam, let it be list after 3 weeks, madam.
Okay, Mr. T. Tagum, Learned Standing Counsel for the Education Department, with the consent of the Learned Counsel for the petitioner, prays for listing this matter after 3 weeks. The prayer is allowed. List the matter after 3 weeks.
Deeply applied.
Lordship, Lordship, in item number 3, 3 and 4, Lordship, interim is there, Lordship. Interim may be continue.
3, 4, and 5 in all the cases.
Okay.
That's something further.
Yes,
It's already there. Until further orders.
Until further.
It is until further order. No
No
need
need,
pass
madam.
order there.
No, Lordship. Madam.
Lordship, I beg to mention item number 7.
Hmm.
We need some more time to file reply in the affidavit in opposition by respondent number 2.
Yes. Mr.
Yes, Iran.
S. Iran, Learned Counsel for the petitioner, prays for further how much time?
4 weeks, Lordship.
Further 4 weeks time to file affidavit and reply to the affidavit so filed by the respondent. The prayer having not been objected to by Ms. Pango, Learned Government Advocate, is allowed. Stop recording. List the matter after 4 weeks. Okay.
May I please say, Lordship? Lordship, I beg to mention an unlisted matter to be listed on Monday, on 17th.
Okay. What is this matter about?
This compensation matter, Your Lordship. We have already filed our affidavit, but recently we got some, yes.
Okay.
Okay.
Monday.
Lordship, in item number 7, interim order is there. That may be continued.
Item 7.
Yes.
The interim order passed earlier shall continue till the next date of listing. Okay.
Item number 1.
This application was under the Contempt of Court Act for violation of the direction contained in the order dated 25/2025. That is at page 15. And the relevant direction is at page 20. Having set aside the order impugned therein, in paragraph
Just a minute,
17.
this is page, the order is at page 15.
Page 15, it starts from page 15. The operative part is at page 20.
Yes.
Paragraph 17. In paragraph 16, the impugned orders are set aside and thereafter this direction had been issued. The respondent number 2, so-and-so, and the bank manager of ICICI Bank Naharlagun branch are directed to restore the bank guarantee number so-and-so, bank guarantee number so-and-so.
Just a minute, just a minute. 16 is?
16 is the impugned orders, those are set aside. In view of the above materials on record, it is observed that the order passed by the learned JFMC UPA on 25/3/2025 and 23/4/2025, whereby initially the bank was restrained from invoking encash the bank guarantee, and by the second order, the JIMA application number so-and-so filed by the respondent number 2 regarding the bank guarantee are not proper, and accordingly the same are set aside and vacated. The respondent number 2, Diwang Natung, the IO, Mr. Khoksi so-and-so, and the bank manager of ICICI Bank Naharlagun branch are directed to restore the bank guarantee number so-and-so and the bank guarantee number so-and-so for an amount of rupees 4,831,000 each, as it was before 35/3/2025.
Order was passed by the session judge. Whether the contempt lie before this court?
Lordship, it is read with rule under section 10, read with section 12 and rule 9 of the Gauhati High Court rules. And for clarification, I'll just would like to place in judgment, which will be amply clear that the contempt lies. That is of
please
1991 1 JLR 214.
Contempt of Court Act. And High Court rules also, huh? Say this
Paragraph 6. From the order dated 26/9/1989 passed by the Division Bench of Civil Original Petition, contempt number so-and-so, I find that the petition was filed directly to this court alleging violation of an injunction passed by the learned Munsif. The matter was referred to the Division Bench as a point raised as to whether such a petition was maintainable for disobedience of an order passed by subordinate court. It was asked before the learned single judge that cognizance of such matter can be taken only on a reference made by the subordinate court to this court. Then 7, Lordship may skip, it is a discussion. Then Lordship may come to paragraph 8. Regarding Rule 9, Division Bench was of the opinion that just because no reference has been made, it cannot be held on the language of Rule 9 that cognizance could not have been taken on a petition presented by the party aggrieved. Regarding Rule 9, it was held as follows. The three moods on which reference has been made in Rule 9 being disjunctive and being independent, we are of the view that cognizance in the case like the one at hand can also be taken on a petition presented by the party aggrieved. Rule 5 would come in operation only when the matter is referred under Rule 9C and not otherwise. Then paragraph 10. In view of the above ratio laid down by the Division Bench of this court, I am of the opinion that a petition for violation of injunction issued by the subordinate court can also be taken cognizance by this court in view of the aforesaid Rule 9, which applies in case of civil contempt other than contempt referred to in section 14 of the Contempt of Courts Act 1971. So, my lord, what the honorable court has in this judgment, my lord, relying on a division bench has said, my lord, the rule 9, the three modes of, my lord, taking, my lord, cognizance of content.
9 of
Rule 9 of the Gauhati High Court rules. Gauhati High Court of, my lord,
Gauhati High
it's
Court.
Appendix
Okay.
7.
72 onwards.
Contempt of Court, Gauhati High Court Rules, 1977. Probably page 280 of the.
Yeah. Rule 9.
283.
Rule 9. Civil contempt. Rule 9. In case of civil contempt other than a contempt referred to in section 14, the High Court may take action A, on its own motion, or on a petition presented by the party aggrieved, or in case of any civil contempt of a subordinate court on a reference made to it by that court. Now, by the judgment I have referred to, there it says these all the clauses are disjunctive, so therefore independent of each other. Rule 5, which imposes a condition that if your lordship comes to the Rule 5, every reference relating to contempt of court subordinate to the High Court. Rule 5. Every reference relating to contempt of court subordinate to the High Court shall be scrutinized by the registrar, who shall place the same before the Chief Justice or any other judge nominated by him in this behalf for obtaining orders after noting the nature of contempt. The judgment, my lord, referred to, my lord, it clarifies that this particular rule comes in force only when the contempt proceeding is sought to be initiated under Rule 9C, not otherwise. The High Court has the power either on its own motion or on a petition presented by the party aggrieved. So we are party aggrieved, we are presenting this, my lord.
Where in the present case? Where this was decided by?
By the learned session judge UPM.
It's not a civil case, civil court.
It's all orders, my lord, which is not criminal contempt, my lord, civil, my lord, civil contempt.
This order was passed.
By
In
the
what
learned
case?
session judge UPM.
What case?
Page 15 starts, my lord.
It's a criminal revision.
Lordship.
It was passed in a criminal revision.
Criminal
Where
revision.
is the reference made? Where is the reference made?
Well, it's though it's an order of injunction, but the reference is to the subordinate, my lord, court. So session judge is a subordinate court to this honorable court also, my lord. There the order was passed by the munsif in a, my lord, injunction petition. So that munsif is also, my lord, learned munsif is also subordinate court.
Where is the reference age required under this Rule 9?
In the judgment?
Reference made to it by that court.
No, reference will come only under subclause C of Rule 9. If the complaint, if the application would have filed before the learned session judge, he would have made an inquiry, then it would have sent to the registrar of the Gauhati High Court. Then registrar would.
This is under.
This
The
is
present
under
case
rule.
is under.
My case is under Rule 9B.
Okay. In the case of civil contempt,
Gotcha.
it's it talk about the civil contempt.
Gotcha.
But this is not a civil contempt. Civil. This is not a civil case.
This is a civil contempt. My lord will find the definition of civil contempt and criminal contempt, my lord, under the Contempt of Courts Act. If I am permitted to read, my lord, this.
Criminal contempt is at Rule 8.
My lord, the criminal contempt is, my lord, something different, my lord, than the civil contempt, my lord. That definition are given in section 2 of the Contempt of Courts Act. If your lordship takes up the definition, my lord, section 2 of the Contempt of Courts Act. My lord,
Yes.
Let rule section 2A, contempt of court means civil contempt or criminal contempt. Then B, civil contempt means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court, or willful breach of an undertaking given to a court. Then criminal contempt C means publication, whether by words spoken or written, or by sign, or by visible representation or otherwise, of any matter or the doing of any other act whatsoever which scandalizes or tends to scandalize or lower or tends to lower the authority of any court, or prejudices or interferes or tends to interfere with the due course of any judicial proceeding, or interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any other manner. So therefore, my lord, the civil contempt is simple, my lord. Civil contempt is willful disobedience of any judgment and decree. So far as criminal contempt is concerned, my lord, it has to be publication or otherwise written or by sign, and by which tries to, my lord, scandalize the or tend to scandalize the or lower or tend to lower the authority of the court. So then it is, my lord, it is not the which court.
What this present case is
it
about?
is this disobedience of the, my lord, disobedience of the direction that contained in the order dated 28/5, by which, my lord, the contemners
order passed by
Session judge lords.
order was
Session
passed by
judge.
the
That
session
means
judge
25/8.
of whom? My lord, 25/8/2025, passed by the session judge on a revision being filed by the present applicants, challenging certain orders. Those were set aside and the direction was given to restore back the FDs. So this order has not been complied with. Any order which is not been complied with or violated the direction or any other, my lord, that is a civil contempt. But scandalizing and, my lord, tending to scandalize, etc., my lord, by written or spoken, whatever, that would come, my lord, under the criminal contempt.
Operative person is at page number 20.
This series order has been passed in the criminal proceeding only.
Then
in the
And it
criminal
must-
proceedings, how the contempt would lie?
But the definition, as I have already read up, doesn't make any distinction with regard to the civil court or criminal court. It is a court.
Yes. See, the rule is also clear. If it is a civil, then why not execution? Why not execution petition? Why not execution proceeding?
Execution is at a different footing. This is a contempt for violation of the My lord, this argument was also placed in the my lord, judgment I have referred to, my lord. So
Now, this judgment refer that is passed by the division bench in the civil original petition.
my lord, the reference was made to the division bench by the by the learned single judge, and thereafter in an division bench has my lord, considered my lord, this. Paragraph 9, your lordship, may can you see me of the judgment? Mr. So learned counsel for the opposite parties has drawn my attention to a decision of Allahabad High Court in Srimati so wherein after considering section 12 of the Contempt of Court Act or 39 Rule 2A and Order 21 Rule 32 of CPC, it was held that it would not be a proper exercise of discretion on the part of the High Court to exercise its jurisdiction under Contempt of Court Act when such an effective and alternative remedy is available to any person. Mr. Sodhi has also placed reliance in Rudra versus State of Karnataka, so wherein it has been held that it is a well-settled principle of law that when there is a special law and general law, the provision of special law prevail over the general law, and when special procedure and special provision is contained in the CPC itself under Order 39 Rule 28 for taking action of the disobedience of an order of injunction, the general law of contempt of court cannot be invoked. That was submission made. In view of the above ratio laid down by division bench of this court, I am of the opinion that a petition for violation of injunction issued by subordinate court can also be taken cognizance or by this court in view of aforesaid Rule 9, which applies in case of civil contempt other than contempt referred to in section 14 of the Contempt of Court Act 1971.
It's repeatedly said it's regarding with regard to civil contempt.
Yes, it is a civil contempt. I am also filing civil invoking section 10 and 12. So far as
Order was passed in the criminal revision.
The nature of
The present
proceeding
order
may
was
not
passed
be
in a criminal revision.
nature of proceeding may not be a deciding factor for whether it is a criminal contempt or civil contempt. This will be defined by the definitions which I have already pointed out before your lordship. It is the court. It is not the civil court or a criminal court. It is not a civil court or criminal court. That criminal court will, if an order of violation alleged against a criminal court, the criminal proceeding will come or as such. The criminal contempt, for criminal contempt, the conditions are different. Once again, I'm reading.
Just for amount of questions. Lord Senior Counsel, kindly satisfy. So this what we'll do, get it listed tomorrow again. Get it listed. We'll get it listed tomorrow again. You also satisfy. To my understanding, this probably doesn't lie. The contempt doesn't lie before this court. So
my whole the entire my submission is that section 9 of Rule 9 of the Gauhati High Court contempt of rules. There's three modes
Yes,
has
yes.
been prescribed.
Yes, 3 modes.
And this has been clarified also by the judgment that notwithstanding the clause
not,
C.
not A, not B.
B, my lord. The
Party aggrieved.
why-
You see, party aggrieved. That is in the you see, party aggrieved. Supposing if this party aggrieved in a criminal, it's an every criminal case. If this is allowed, then probably everybody will approach the High Court. Let us just confirm we'll get it listed again tomorrow. Okay. Hmm. Relist it, relist this matter again tomorrow on, write the date, huh? Okay. Hmm.
Gotcha.
Hmm.
Thank you, miss.
Item number 2.
Your Lordship.
Just a minute. Huh? Just a minute. Huh? Okay. Yes, sir. इतना था. Okay. Total readings. Yes.
Your Lordship, I'll sort my, make my submission very brief, my lord. I will lead your.
No. What is this matter about?
It
Okay.
is about, your Lordship, the petitioner has been superseded by a junior, my lord.
Superseded by?
A junior, a person who is behind her in the junior.
In what post?
It is regarding ALC, regularization of ALC under this recruitment rule, my lord.
The petitioner was serving as ALC.
ALC, my lord.
Which district?
Siang district, my lord.
Okay.
Siang district. Since
what is what the rule says? RR says?
Rule says, your Lordship, after 15 years, if she is qualified, 50% will be this regularized through DPC. Number 1 criteria, seniority. And number 2 criteria, your Lordship, performance and this punctuality and this fitness certificate. These 2 things are prescribed, my lord. And I have been effectively eliminated by the respondent authorities.
Effectively?
Effectively this eliminated.
Eliminated.
Yes, my lord, by depriving me from placing my record before them, my lord, because this was not called, my lord.
Before your name,
my service book
case was not called for.
My lord.
Not placed before the DPC.
Yes, my lord.
The DPC sits at the interval of how many?
DPC. Your Lordship, DPC.
Every year or?
No. Whenever, my lord, whenever this
post
arises. So,
okay.
my lord, I would this.
So this DPC said after how many years?
4 years, my lord, I think.
Okay, department maintain the seniority list.
Seniority list, my lord. My seniority list is in the page number 41, my lord. Page number 41.
Your name appear at?
Your Lordship, petitioner name is in serial number 3, my lord.
3.
My lord. And private respondent is page number, serial number 4, my lord. And your Lordship, appointment order, impugn appointment order.
Private respondent 4.
Yes, private respondent he is junior than me in term of appointment also. Please see the mark this date of appointment also, my lord. I was appointed on 5/11/2024, 5/11/2004, and she was appointed on 33/2005. 1 year
okay.
later.
This was issued when?
My lord. Order, my appointment order, my lord.
No. This seniority list, this is being maintained by?
Additional Deputy Commissioner, my lord, under whom we are, he is our immediate controller, the controlling authority, my lord.
Okay, then where is the?
Your Lordship, I would like to take your Lordship to this impugn order, my lord. Please come to page number 56, where this PR, private respondent number 4, has been appointed, my lord. Page
page
56, my lord. It is the impugn order. And after that, I will take your Lordship to the
just a minute.
DPC also, my lord.
Just a minute.
My lord.
This is impugn order.
My lord, page 56, my lord. Her name is reflected in this name, my lord. Srimati, this, my lord. She is the private respondent.
Private respondent?
Yes, my lord.
Just a minute, sir.
My lord.
The recommendation of DPC.
Paragraph 11. Is it respondent number 6 kasi pa 5 6.
So both are in the same place, Rumgong.
My lord, your lordship, Rumgong. And your lordship, interestingly, my lord, the manner in which they have this conducted their
Just a
DPC
minute.
minute, my lord.
Just a minute. Huh?
My lord.
Okay, what happened thereafter? After this order?
After this, my lord.
Has she joined?
Yes, she has joined, my lord. She has joined. There is no dispute on that. She has joined. Therefore, my lord, I have filed a representation before them, my lord. It is in page number 57, my lord. Your lordship, before going to my representation, my lord, please see the manner in which they have this call for this ACR, my lord, or this service book, my lord. Just one this. I don't want to delay this court because your lordship's time has been consumed in division bench.
Okay.
My lord, please come.
Okay, this is way back in 25. I thought 26. But,
My lord. Page,
yes, more than years gone.
so we are not
Page.
page 52, my lord. Page 50. See the manner they have called for, my lord. What they have said, my lord.
Just a minute.
Please see, my lord.
52 is a WT message.
WT message. They have called for service record, my lord. Service record, and what they did. May I read your lordship?
Yes.
Request to send the service books of the following staff under your disposal on or before 25/7/2025 as follows. 1. Sri K. Nair, LDC. 2. Sri R. Ram, handyman. 3. Srimati Y. Ketan, ALC. Your lordship, this is just above me, my lord, but she is not qualified. She is just above me. She is in serial number 2, my lord.
Okay, 2 also not appointed.
No, she's not disqualified also, my lord. And after that, my lord, 4 is SMT A. Tamut, ALC Rumgong. She's also not appointed. 5, just.
She is also above you.
No.
Oben.
No, she is also not. No, she's below me, my lord. She's below me. She's
Okay,
not,
she has not been, her case has not been considered.
But 5, kindly see 5, SMT Y Muje, ALC Rumgong, my lord. Just top above me has been invited, called for, and just below me has been called for, but my service book has not been called for, and by doing this, they have effectively eliminated me, my lord, for this prior consideration before the DPC, my lord. Your lordship, and another thing, my lord, please come to the conduct of the DPC, the way they have drawn the minute of DPC, my lord. Page 53, my lord. Page 53, my lord. This. Page 53, my lord. Nothing has been done. No comparative assessment of seniority and nothing, my lord. No statement of any analysis of individual merit, just, my lord. Just recommended. Principally recommended, my lord. Please see. Nothing. Just what they have marked, my lord, in paragraph number 1, my lord. Agenda of the DPC, my lord. May I read, my lord?
No, para? Okay, agenda, okay.
All necessary documents such as the seniority list, recruitment roster, annual performance appraisal report, APAR. Your lordship, I don't want to go in such technicalities. Nonetheless, your lordship is very clear, my lord. APAR is not required for this such contingency, my lord. Nonetheless, I don't want to be hyper technical there, my lord. This is this. No objection certificate. recruitment rules and vigilance certificate were made available for the committee. The service record were thoroughly examined. No comparative assessment matter, thoroughly examined just. And after detailed scrutiny, the following the DPC recommended the promotion of the official staff with effect from the date of the DPC meeting on 28/7/2025, my lord. They said promoted. Actually, it is a regularization, my lord. So it was this way, my lord. This way. Even this also has no comparative assessment, my lord. Nonetheless, my lord, at this stage, your lordship, I respectfully submit. I don't want to be hyper technical because your lordship at this stage, my lord. My simple, this limited prayer would be at this stage, my lord. Please come to my prayer, my lord. Page number 32, my lord. Just limited prayer. I'll be prayer 6, my lord. May I read?
Page?
Page 32, my lord. Page
Okay.
32, my lord.
Mhm.
Please direct the respondent number 3 to dispose of my petition, my representation, my lord, pending before them, 2025, my lord. It is posted in this page number 57, my lord, and it is not yet addressed by them, considered by them, my lord. And along with the small liberty, my lord, 7, my lord, if I am fit, my lord, if I am fit, paragraph 7, my lord, if only and only if I am fit, my lord, if I am not fit, should not be applied, my lord. If I am found fit, if there is any during the consideration of this representation, if any vacancy is there, and if I am found fit, I may be considered, my lord. This would be sufficient for this stage, my lord. If they arbitrarily deny me, my lord, even after this.
So if your prayer is limited to the extent that your representation be disposed of, and if there is a post, your case be considered. You want this disposal of this writ petition?
Yes, my lord. Yes.
Representation will be disposed of.
Okay.
Right.
So what if not considered?
Your lordship will obviously give me this liberty to challenge their.
Because you have a good case, it appears.
Yes, my lord. Yes, and I have a very good case, of course, my lord. But I think they also, in fact, I should not make this submission before your lordship, but I have done that they might also consider.
Okay.
Your lordship is absolutely right, my lord, because they have effectively, in fact, they have effectively eliminated me from being in the zone of consideration, my lord. Now my problem is that even I cannot go for this, as your lordship has rightly detected the date of appointment order, interim order, my lord. I cannot go for this interim order and stay order also, my lord. That's why, my lord.
Hard, Mr. Jamo, P. Jamo, learned counsel for the petitioner. Also had Ms. Wangmo, learned government advocate for. Hearing for respondent number
1, 2, 3, and
1, 2, and 3.
4 and 5.
4 and 5. Start. Huh? Start. Huh? By filing this writ petition under Article 226 of the Constitution of India, the petitioner is seeking the following direction. Okay, the prayer, huh? Okay. The case of the petitioner is that she was appointed as ALC.
ALC, my lord.
Where? You just,
on-
I think we have a less time. You just give me the date, whatever I ask, okay?
My-
Furnish
my-
me the information.
Your Lordship,
She was appointed as ALC on
5 November 2014 or 4,
5/11/2004.
4. Yes, my lord. But
Where do we find this?
it is in page number 39, Annex 2, my lord.
Page 39.
Annex 2, my lord.
Just a minute, huh? Is there any type copy?
Yes, my lord, just behind, my lord. Page 40,
Okay, page 40.
my lord.
Which page 40? Appointment order. In the same place, Rumgong,
My lord,
since then.
yes,
Okay,
still they are there.
okay. And then thereafter, then she was appointed as ALC on 5/11/2004. And since then, she has been serving as ALC under which, under
Additional Deputy Commissioner.
Additional Deputy Commissioner Rumgong
My lord.
staff, huh? It is para, the Land Council for Additional submits that the department maintain seniority list of the contingent staff under ADC Rumgong.
My lord.
And in the said seniority list, the name of the petitioner appear at serial number
3, my lord.
3.
My lord.
Okay. It is submitted that the father, as per the, have you annexed the RR also?
My lord, my lord. Please,
Where?
page number this, there are two errors, my lord. I would go direct to the amended latest, page number 21, or 47, my lord.
Page,
It is amended.
page
my lord.
47.
47, my lord.
Okay.
Annex 6.
As per the recruitment rule, what is the name of the recruitment rule?
It is the, my lord, the general Arunachal
Recruitment rule,
stop.
the, within bracket, the, namely, the General Arunachal Service Multitasking Staff, within bracket, Daftri, stroke peon, stroke chokidar, stroke mali, stroke dak runner, stroke sweeper, stroke kennel man, stroke water carrier, stroke cook, stroke washerman, stroke cobbler, and equivalent post within bracket close, comma, non-gazetted group C, non-ministerial common recruitment
Amendment, my
amendment, first amendment rule 2021,
my lord.
comma, the,
Para 2, my
the para 2,
my
where do you find? So under, then, under, it's a section,
yes, section
the rule 2,
rule 2, my lord.
para 2,
Yes, my lord.
the rule 2 of the, this rule, huh, okay,
50%.
provides that 50% of the vacancies
Right.
shall be filled up from amongst the serving unskilled contingency staff, stroke auxiliary labor, and all those, same.
My lord. With minimum 15 years continuous service, my
Labor, with minimum 15 years of continuous service in their respective office, stroke departments, and possessing, education code, you think that you are eligible?
My lord, I have submitted.
Okay,
I have annexed here, my lord.
then educational qualification of class 10 pass,
Right.
stroke ITI or equivalent pass certificate from recognized board or institution staff. It is submitted, the petitioner is, what is her,
ALC.
her qualification?
Matriculation, my lord, matriculation.
Pass her, is eligible for such promotion no, they submitted that the petitioner is a class 10 pass, and as such, she is eligible for such promotion. For consideration for
Yes.
promotion to consider for regularization. It's called regularization only. Regularization of our services ALC staff. Hmm. However, okay, the Alana Council for petition submits that. Although she is qualified, she is eligible for recommendation of our name for consideration for regularization of ALC, the respondent authority, Deputy Commissioner.
My lord, Deputy Commissioner, my lord.
He is respondent number?
The respondent number 3, my lord.
Deputy Commissioner is respondent number 3.
My lord, yes, I think my lord, yes, my lord. 3.
The Deputy Commissioner, respondent number 3, hearing has.
Your Lordship, for technical requirement, we had to, let's say, implement departmental promotion committee headed by Deputy Commissioner also, my lord. So it would be respondent number 3 and 4, my lord.
Requested by WD message dated 23/7/2025 addressed requested the ADC is respondent number requested the ADC respondent number 5 to send the service book of the staffs. However, in the said letter, the staff by mentioning the name of the person to be sent. So, however, in the said letter, although the name of the ALC working under Rumgong so from the ALCs from the list of the ALC, the name of the ALC under serial number 1 also called for.
No, my lord, he's over. They're not qualified.
Okay, 2 and 4.
Yes,
And 2 and 4 was called for. However, the
petitioner who is in
name
number
of the
3, my lord.
however, the name of the petitioner found missing from the said letter. Staff on para. It is further submitted that pursuant to the name furnished to the Deputy Commissioner, who also is the head of the, who also headed the departmental promotion committee. The case of the other person, including the respondent, who is junior to the petitioner, the respondent or private respondent number. She is private respondent number 6, whose name appear just below the petitioner, has also been considered. And subsequently, and already by an order dated 31/7/2025, the private respondent number has been offered an appointment letter. An appointment offer an appointment now. No. By an order dated 31,
My lord.
7/2025, the private respondent has been appointed as ALC.
My lord. No, no, MTS, my lord.
MTS.
Regular is MTS.
Okay, regular. Where do we find the post? Where do we find the post where this respondent has been? Where is the exact post name?
My page number 56, my lord.
Okay, 56.
My lord. Appointed to the post of MTS beyond, my lord.
Huh?
MTS.
MTS beyond.
My
Appointed as MTS. Okay.
My
Promoted, huh? Promoted. It's a promoted, they say.
actually there.
Promoted and appointed
My lord.
to the post of MTS within bracket peon against sanction order dated 9 March 2027. Stop. Being aggrieved by the said order, the petitioner has submitted a representation before the respondent number 3 Deputy Commissioner requesting for consideration of her case for promotion and appointment to the post of MTS, a regular MTS. However, the said representation, submitted representation dated 28/2025. However, the said representation is still lying before the respondent authority without any consideration. Stop. Para. The learned counsel for the petitioner at this stage submits that he has at this stage he has a limited prayer that that rest I will dictate. Okay, limited prayer that to dispose of your since you have submitted your representation, the respondent authority may be directed to dispose of your representation dated so and so.
Well,
and to consider your case for appointment as MTS.
Yes.
Okay, and you have no grievance against this respondent number, private respondent.
no, that, yes,
Okay, and consider her case for appointment. Okay.
Okay.
I'll conclude it.
but my lord.
And I will submit that you have no objection to the extent that the direction is given to the respondent authority to consider the case of the petitioner. Okay, and dispose of the representation submitted by the petitioner. Okay, and I will give some date around 60 days or 3 months.
3 months, Your Lord.
Okay. Okay, dispose.
Item number 9.
My lord, I'm praying for adjournment of the matter for today, Your Lordship. Senior counsel, Mr. Tara, he had to leave due to family emergency, Your Lordship. Peer on behalf of
Learning counsel. Oh, yes, no objection. Yeah, okay. Learning counsel, submits that. Praise for adjournment of the matter for the day, to which Mr. L. Parme, learned standing counsel for agree. And okay, Ms. Pango, learned counsel, learned government advocate for the state respondent, and Mr. L. Parme, learned standing counsel for the agriculture, has no objection. Accordingly, the prayer is allowed. List the matter
2 weeks, Your Lordship.
after 2 weeks. Okay.
Oblige.
Item number 10.
Yes. Mr. Parme, you are for the respondent.
I am for respondent 2, 4, 5, and 6 mail.
Okay, none appears on behalf of the petitioner on call. However, Mr. El Parme, the standing counsel for Power Department, For respondent number 2, 4, 5, and
6, my lord.
6.
2, 4, 5.
He is present. In absence of the counsel for the petition and the matter, stand adjourned, release the matter after 3 weeks. Okay.
I will.
Item number 12 and 13.
Your Lordship, I'm from the petitioner.
Petitioner.
Your Lordship, the service is still awaited for respondent 2 to 7. Therefore, Your Lordship, we beg you to humbly give us some more time for the service to be
No,
taken.
service unserved notice has been received back. Probably you may have to take fresh steps. Why it has received back? Do we have any information? Why it has been received back? What information? What is, postal note? Is there anything? It's not reflected here. Just see it once. Miss
D. Kumar.
D.
D. Kumar.
Planning Council for. Your name is there?
I'm appearing on the behalf of leading counsel J. Jongruju.
Okay, now. Planning Council appearing on behalf of Ms. J. Jongruju, Planning Council for the petitioner. Staff, the also has.
Ojera, Your Lordship.
Zerang.
Appearing on
Planning
behalf
Council
of
appearing on behalf of
M. Kato for
Mr. M.
Respondent number 1.
ESGI. For respondent number
1, Your Lordship.
1. Postal receipt. It's not there. Neither ID card nor unserved notice has been received. Okay, not received. Sorry, I thought it's received. Okay. The office note dated 12/8/2026 reflect that the notice upon the respondent number 2 to 7 is still awaited. In view of the above, let the matter be listed after 2 weeks. Okay.
Much
Item number 14.
This is 12 and 13, huh?
May I, Your Lordship?
Yes.
Your Lordship, this matter has been become infructuous, Your Lordship.
Okay.
Your Lordship, the present case, Your Lordship, we have initially challenged the order when the premature transfer was from Pastiga to 0 division.
Okay.
However, during the pendency of this case, Your Lordship, there was another transfer.
Okay.
Order. To that effect, that the petitioner has already
Okay.
become infructuous. So
Had Mr. Jambison, Planning Council for the petitioner. Also had Mr. Who, Mr.
Yes, Lord. I'm for 1, 2, 3, 4, 5. 1, 2,
Okay.
5. Standing Council RD.
Which are for the respondent number 1, 2, 3, 4, and
5.
5. And Miss.
Respondent number 6, Your Lordship.
Okay. For respondent number 6 and Mr. Perme for respondent number 7. Okay. Stop, huh? Mr. Jambison G. sitting, Planning Council for the petitioner submits that this during the pendency of this writ petition, the petitioner has already been transferred to
Daminhuri.
some other
Daminhuri.
Daminhuri, and he has already joined in his posting place. Thus, it has been, and therefore the matter has become infructuous. In view of the above, this writ petition stands close on becoming infructuous. Okay.
Item number 15 and 16.
Yeah, please, Lordship. Lordship,
And there one more last, because and in person to the said transfer to the Damin Huri and in person to the order. He has already got person to order. Okay.
yes, Miss Lordship, this interlocutory application is for withdrawal of connected with petition, Lordship. This interlocutory application is for withdrawal of connected with petition.
Okay.
Since the matter, the petitioner is desirous to pursue the matter before the competent authority, that is the Deputy Commissioner, Capital Complex. So I humbly pray that Your Lordship, the connected with petition may be withdrawal.
Okay, 346.
346 of 26.
Heard, Mr.
T. Gao, Lordship.
Land counsel for the petitioner, applicant, huh? Start from by. Also heard Ms. Sangeeta, land government advocate for the state respondent. Start from by filing this application, the applicant stroke writ petition seek permission to withdraw the writ petition being number WPC 346 AP 2026 pending adjudication before this court with liberty to pursue the statutory remedy stroke appeal under section 12 of the Arunachal Pradesh Public Premises within bracket Eviction of Unauthorized Occupant Act 2003. So this is also pending before the Deputy
Yes,
Commissioner?
Lordship.
Okay, pending before, the pending consideration before the Deputy Commissioner, Itanagar Capital Complex. Staff, the prayer so made by the counsel for the applicant petitioner, writ petitioner, has not been objected to by Ms. Sangeeta Lana, government advocate for the state respondent. Staff, in view of the above, the prayer is allowed. Okay, this writ petition stands dismissed with liberty as prayed for. Okay. With liberty, okay, with liberty granted to the petitioner as prayed for. Okay.
Leave obliged.
So, okay.